On the last, on 31st 10, on special mention, the matter has been taken up. Your Lordship has issued notice. And
my Lord, item 70.
Two more of those.
My Lord, item 75, the Jagannath
That
case.
under sexual harassment.
My Lord.
The prayer is for reconstruction of the file, my Lord.
Reconstruction of file. Which is that famous judgment where file is lost, how to build a new file. There is a Supreme Court judgment.
Yes,
bring that judgment. If you bring, I'll take up the matter. Yes, sister.
For OP3, my Lord. Yes, ma'am.
Matter was referred to mediation center. There is a report as per the cost title.
Anything happened? Is it a failure report or a happy report?
That report is not applied to us.
My Lord,
Flag A, your flag A.
I have to call the mediator to read it. I cannot read it. Of course, I cannot read my script also. That's another thing. At least this script I cannot read. Can I read it? Is that right? See that what he has written, he has scribbled something on that. Is it a positive?
yes, ma'am.
You have that copy?
Yes, ma'am.
Yeah, read.
Dated 3/9/25. The mediation is fixed today. Petitioner, opposite party 3, opposite party number 4, secretary, opposite party, cooperative society.
During course of
discussion, the petitioners submit that the opposite party number 5 accused their prayer of agricultural debt relief and other is no claim against the opposite parties. The petitioners further submit that during the pendency of the writ petition,
you want to withdraw the
advocate expired. Their advocate expired, so they cannot withdraw the writ petition. Now they want to withdraw the case. In the above mentioned circumstances, the writ petition become successful.
How it becomes successful without my audience? Now they want to withdraw the case. What is? We'll say that you want to withdraw the case.
Yes, my lord.
But all mongoose, cobra, everything he has put in that report. He says, I don't want to withdraw, but he says, I can. The matter was referred to mediation. Elements of amicability having been discovered on the previous occasion. Wide order created first time. The order reads 28/7/20. Next one. Learned mediator, in terms of the above order, has submitted a report which reads as under. First off, there is some inconsistency and incongruity in the text. First off, however, the perusal of the text, both in the opinion of this court and in the opinion of the bar, shows that this petition needs to be disposed of as having been withdrawn, since such a sentence conspicuously appears in the third paragraph. Second paragraph. First. Next. In the above circumstances, petition is disposed of. Okay. If there is any misconstruction or misunderstanding about what the report really means, it is open to the concerned party to move a memo seeking recall of sorry. Okay. Because he is not here now. Your friend, just tell your friend also. Petitioner counsel.
There is mention, my lord, that petitioner counsel is expired. That's why they don't argue the case. For
No,
But-
to withdraw the case, there is there?
Yes.
Sentence is there.
Yes, my lord.
So, register copy of this order to the counsel for the petitioner, to the petitioner
Petition.
party in person. Petitioner parties in person. Okay? By speed post immediately. For their information and needful action, if any. Okay. Next.
Item 2.
Yes.
May I please, madam?
Yes, sir.
My lord, in this case, the villagers are before my lord. They have submitted a representation on Annexure 3 and Annexure 4. The recommendation is also under Annexure 5. Because the mistake is that the name of this.
They want to change the name of this school.
Yes. Recommendation is
The
pending with the-
block education officer has recommended for such change.
Change.
And
Then
it's
what
not-
is your objection?
No,
Why it is
well,
not being.
only on 11/8/2025.
There
There is so many. Is it not writing the constitution? It is writing the new name. About 1 hour, 2 hours it should be. Why so many days?
Lakshmi.
Because I'll allow that petition. I'll not send it back. The short grievance of the petitioner is as to the long pendency of his request for permission to change the name of the school. First off, the essential elements of this are reflected in the representation dated.
Representation on Annexure 3.
It's in your language. Of course,
Yes, my lord.
it's my language.
It is 2008.
Date of the day. That's Annexure 3. First. The
2000.
counsel for the petitioner argues that the block education officer wide endorsement dated
11/8/25.
11/8/2025 has recommended case of the petitioner. And despite that, the jurisdictional authority, namely the district education officer, is sleeping over the same. First, next paragraph. Learned counsel appearing for the office on request submits that the prayer is innocuous and therefore innocuous, and the DEO himself having recommended in case of the petitioner, there should be no problem, no difficulty in granting the request made in the subject representation. First off, with this proposal, counsel for the petitioner is agreed. In the above circumstances, this petition is allowed. The OP number so and so D
9.
is hereby directed to immediately permit change of name as indicated in the subject representation and report compliance to the Registrar General of this court within 1 week, 2 weeks, in 2, failing which the DEO may be asked to pay ₹1,000 per day. First off. Now no costs. Okay.
Item 3.
The opposite pad number 9.
OP number 9, DEO.
DO.
Why he wants something? Therefore, he is keeping that pending. When the DEO has recommended, why DEO is keeping it pending? Yes.
My lord, I am for the petitioner. My lord, petitioner is file one transfer application, one establishment to another establishment of provident fund account. That in 2015 is still pending.
One establishment to where they are.
She was working under one private organization, on opposite party number 1, and after that she left that private organization and joined to this Shiksha Sahayaka is one service under the government school. Then she joined directly government servant, presently working in high school, and that 2 provident fund account was pending. I want to transfer one account to another establishment account. And 2015 onwards, Form 13 is online transfer is applied. That is still pending. And she has come to this
account.
Yes, ma'am.
Account.
Yes.
Where is your representation?
Annexure 3, my running place.
Who should look into regional PF commission?
I am for the people. Now, all these online applications are there. It should be forwarded by the employer so that it can be done. So now I have to take the instruction. What is the status of the application?
My lord, she has come
Not
to
that
this
you need to
honorable.
apply. The employer, yes.
Take notice now.
Yes, sir.
I call this day after tomorrow. You have full information from the officers, then we do.
One
Can't
time,
keep it
one-
pending. How many? How long?
1 week time.
Huh?
1 week time.
No.
My lord, pardon, my lord. He has come to this honorable court, and this honorable court is instructed to follow up. And after that, still also pending. Yes.
So 1 week we give.
Yes,
Yes.
Next week we do. Yes. Whether notice has gone to others?
No.
So learned panel council appears for OP number 1. The notice written within 1 week. Two OP numbers 2 and 3. First off, what this matter immediately after service. First off, in addition to taking legal steps, it is open to the petitioner to take Muktam, service by Muktam, if he so chooses.
Copy of the one.
You copy. Yeah. Copy and copy, both. Yes.
Item 4. So the retired headmaster, in action opposite for sanction of RSU of public MSCT.
What
Similar.
is judgment?
Yes, ma'am.
Have you changed the dates and other things?
Yes.
You that. This sentence is incomplete. Okay? But you have done another day. We are changing it. Plan. Change it. Just look it. Yeah.
Item 5. NSO 13, the input order lawsuit and pay 36.
56.
Can I read my?
Yeah. What it says, you tell me in your words.
And what happened in NSO 11, page 32, the government has allowed the UGC scale up to the petitioner, the SS candidate.
Take notice. About that, what you like God's notice for.
Petitioner retirement. The education.
Take up then he requested to accept notice for 1, 2, 3. Emergent notice to 4 and 5. Yes.
Item 6.
May it please your lordship. Here in this case, the petitioner before lordship is a retired secondary school headmaster and who was retired since 30th April 2023. Your lordship may kindly give emphasis to the date after attaining the age of superannuation, Miller.
Gratuity and consequence.
Yes, Miller. Final pension and gratuity, Miller. Case is there. Problem is there, Miller. Here, Miller, he was retired since 30 April 2023, Miller. And the provisional pension was prepared by the concerned authority prior to the retirement, that is 4 days before. That is
Let notice go. So that you will answer your question.
Yes, Miller.
Emergent notice.
Your lordship can pick up a yearly date.
Criminal case is pending, that is.
No, that is law does not permit, Miller. Law does not, I can clarify it to your lordship, Miller.
He is saying. Yes,
I have annexed everything. By seeing my annexure, he is replying. By reply by saying I have not.
Not reply you, file Mr.
Yes.
But that will not be a justification, as he rightly says. Issue emergent notice. Let Mr. Lenka learn DJ requested to accept notice for 1, 2, 3. Emergent notice 2.
DO is the concern. DO is the discharging.
OP. Follow. Matter lies in a narrow compass and therefore post this matter in the week after next.
We commencing from
Week after next.
Miller.
Notice to opposite party number 4.
4.
Yes.
Forget. Like
Raghunathi Government.
OP number 4, Miller. OP number 4 is the headmaster, school concern, Miller. These are the authorities.
You have made him part B. You have to take it. Yeah.
Problem.
Item 7.
May I please, your lordship?
List.
Item 7, my lord, this matter relating to that change of seniority by the opposite party unilaterally. Your lordship can have a glance to page 43, annexure 9.
I am issuing notice.
Yes, your lordship, in similar such matters, your lordship already issued notice. Number I am giving 26645 of 2025.
266.
45.
45 of
25, my lord. And your lordship directed those matters to be listed in the last week of October, but it has not been listed. May I play your lordship fix a date coming week on a week after?
Other connected matters. Next.
Item 8.
All the matrimonial relating to covered by lawsuit judgment. In the case of Loknath,
Copy to
yes, Loknath Bear. Only to the name and date to be corrected. And date of the order. All the other things same.
in all these cases, prayer is same.
No, prayer
differs, because date still are.
Yes, the entitlement date is different.
Mr. Monty, we have already granted a kind of likhna.
Kind of.
That way we do.
And also, as per my information, writ appeal is also pending. However, it will be disposed of accordingly. It will be out.
Can we add one sentence? This order shall be subject to the outcome of the writ appeal. So that we need not take this matter in writ appeal.
Exactly.
This order is subject to outcome of the pending the writ appeal number.
Number I will give.
Collective. Okay? But otherwise, they need not. Otherwise, they have to file again.
You'll also directed to yes. You'll also directed to consider in the light of Loknath Vera. Yes.
Next.
Item 9.
9 matter that block grant pension matter. Similar matter will also already issued notice. I am giving the numbers.
Yeah. Somebody just copy. The validity is requested for such notice for all.
Yes, one the
No.
of management.
My lord, except
1 to 5.
except
6.
5 and 6, my lord.
No, 5 is also.
No, let it go. Controller of accounts, you are a
Yes, yes.
Monthly in other matters.
6 is
1 to 5.
1 to
1 simple of them. Like in an arrow compass, post immediate officer.
Along with that other matter. Along with the others.
Along with the
Item 10.
Yes, brother.
This is the disciplinary proceeding. The order passed without conducting the inquiry as per the rule 15 of OCS's rule 1962.
They have not followed the rule.
Yes, my lord. No portion of the prosecution was recorded by either by inquiring officer or by disciplinary authority. The disciplinary authority did not issue the show cause notice containing the inquiry report. The order itself was flawed, as the same is amalgamation of minor punishment and major punishment. My lord, the charge memo has been framed under rule 96, under rule 16 of 9 OCS, but it has been
1 to 4.
1 to 4.
major penalty has been imposed, my lord. Though it is.
Let us see no into model now.
Item 11.
Yes.
11, my lordship.
Yes.
My lord, the fact of the case is that, my lord, petitioner name could be changed because the name has been inserted.
Correcting biological father.
Father is alive, my lord.
Biological father's name.
Yes, well, only prayer is so. And that will be considered by the board authority.
Here, my lord, Board of Secondary has their panel of lawyers. Either to dispose of with a direction to the sole opposite party.
Sure, but their lawyer is not here. Anybody is here? Mr. Rao?
Sir is there.
Consider name of biological father, but there are many other.
Let him give a copy.
Let him give copy.
Yes,
I will direct consideration.
Yes.
But it is not that simple. The concept of legitimacy.
Only I am derived from my parent.
You have come without preparation. I have come with full preparation. I have done hundreds of such matters.
Because I am being derived from getting the parental property.
Anyway,
only this is the yes.
Petitioner has made a representation seeking entry of biological father's name in the records of his school. The representation dated what is dated 24/10/2020? No, what date? Why people, our office people are. Why do you put since on the dates? So much space is there.
This is at
2025. This is the explanatory. And the same reads anexually. One with same thing, second one, another. First, Learned senior panel counsel on request appearing for the board very fairly submits that if a reasonable period is prescribed and all contentions are kept open, there would be no difficulty in giving a decent treatment to the subject representation in the hands of appropriate authorities. First, this satisfies the counsel for the petition. Next one, in the above circumstances, petition which is put up, time for compliance is 6 weeks.
Yes, I know. Before
If the copy of this order, registry shall send a copy of this order to whom it should be sent. To secretary. So again, he need not approve because once he goes there, what all they demand, we don't know. Yes. Registry will send a copy of this order to which authority it should be sent.
board authority,
To all the OPs. To all the OPs.
can you listen?
Item 12.
Yes, next.
12 my lord, on behalf of Mr. Mahapatra, next week.
Which for 11.
12 item 12 on behalf of Mr. Mahapatra, next week.
Lord, may I say in item 12, let my learned friend correct because the impugned order is an extra one. In fact, there is no letter. So let him directed by that it will not.
Yes, that lawyer will. Yes. On this matter, next week. First off, petitioner is permitted liberty to effect the marginal changes.
Item 13.
Aim for appropriate order.
Here,
Despite the judgment passed in Sri Satya Sai Seva organization without jurisdiction, opposite panel number 3, learned sub-collector has withheld the salary of the petitioner who has been working as the principal cum secretary of the college.
Any disciplinary proceedings?
No, nothing else. This
Why, brother? Why? Similar matters are coming before me. Na? About 6-7 matters have come like this. Are they acting like Mughals?
no, my lord. So far, it's held up since July.
Yes.
But there is a question of their prayer that for reprehension. But in fact, there is no such reprehension.
Anyway, now you take notice. Let them. Have you given representation?
No, but representation. I have given appeal to the such and such to the sub-collector himself.
Appellate authority.
But
no, you're not answering. You are not clear in your expression. Have you given representation?
No.
Representation to the sub-collector I have given.
To whom you should have given?
We should have given to the director.
I'll permit you, and if you give representation, they will consider that. Within 4 weeks. Petitioner's prayer is treated as personal. Petitioner's representation dated 11/10/2025 at Annexure 11 reads as under. First, it is addressed to the President of Governing Body, the Sub-Collector Indrapara. First, next paragraph. Learned Mr. Mohanty, accepting notice for the OPs, submits that if representation is given to the jurisdictional authority, there would be no difficulty for considering the same in a time-bound way, because all contentions be kept open. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make an appropriate and comprehensive representation coupled with all evidentiary material in support of his claim. Two.
Opposite party number 1. Commissioner Secretary.
One. And if one be made, the same shall be considered, and result of such consideration shall be intimated to the petitioner within 4 weeks following. All contentions.
Item 14.
Yeah, please, man. In this case, my lord, the petitioners are the chairman and member of the school managing committee. my lord, filed a representation before the state government to inquiry to
Take action in terms of inquiry report.
my lord. Annexed
Where is the inquiry report?
annexed to my lord. Your lordship, the DO submitted. Yes,
Wait,
16, my lord.
16.
My lord. The district education offices.
I'm reading it. Take disciplinary action. Who are you?
My lord, I am the school managing committee. Our allegation, this inquiry was made. We are the school managing committee and the member of the school managing committee.
But you are part of the committee.
No,
You have convinced other members.
no, we have, my lord, in our allegation, the state government directed to DO to conduct an inquiry, and DO conduct the inquiry, submitted report to the director. Director has not taken any action, my lord.
The director has to take the action.
My lord.
Which is the rule.
Annexed to my lord. The director is the disciplinary authority, my lord.
The director happens to be disciplinary authority. Mr. Monty, yes. The short grievance of the petitioner, who happens to be a member of the managing committee of the institution, is reflected in the prayers column. This is not well traveled. Come on, as a son. First. Next. Learned counsel for the petitioner submits that when there was a direction to hold the disciplinary inquiry against the teacher,
Against the headmaster.
The headmaster of OP number 5.
OP number 5. And when the inquiry having been held, the inquiry report has been submitted to the director on 10/9/2025 as per Annexure 2. Come on. The jurisdictional authority cannot sleep over the same, inasmuch as the inquiry is held for a particular purpose and not for accomplishing some ritual. First of all, there is force in this submission. Next one. When Mr. Mohanty, learned AG's attention is drawn to the report, he very fairly submits that the report has to be acted upon this way or that way by the concerned authority. Of course, after furnishing a copy thereof to the employee in the light of the apex court decision in Muhammad Ramzan Khan versus so-and-so 1991 Supreme. First one. Therefore, much adjudication need not take hands of great court. Next one. In those circumstances, petition is disposed of, directing
The OP number 2.
OP number 2 to take a call on the subject inquiry in accordance with law and in a normative, all contentions having been kept open. First one, this to be done within a period of 4 weeks. Reckoned from this day, now no cause. The next day, on the next level of litigation, heavy costs may be imposed on the authorities who are responsible for not taking the decision on the subject. Registry to send a copy of this order to OP number 5 by speedy post. Yes.
Item 15. Item 15, my lord, similar matter, your lordship has already issued notice. My lord. That reservation matter. Women reservation matter.
Issue a first notice. The DG, we should go to first title. Accept notice for.
My lord, the state will be a state. 1-2.
Emergent notice will be the rest. Post office service.
3 to 7. I'll
all along with the
Private parties are there. Then
yes.
3 to 7. My lord, I'll take. This matter may be taken up along with 22,827 of 25. My lord.
Item 16. Item 16 regarding investment matter, similar matter also will dispose of.
Pending.
No dispose of my
Dispose of.
All the
copy with you.
Yes, we have already solved. All the material
same.
Yes, only change the petitioner name and diplomas. Prayer also.
That WP is not stayed.
No.
Ashok Kumar Mahapatra
Yes, sir.
Is in appeal now?
Yes.
No.
no, my lord, this is fixed that for a final hearing in the month of November. It is 30 years.
Subject to will say this order. This order is subject to outcome of the pending writ appeal against Ashok Kumar Mahapatra.
Ashok Kumar Mahapatra.
No writ appeal.
No, it has been completed. Man, final for the purpose it has been fixed to.
Next. Same one.
Item 17, similar.
17.
Short grievance of the petitioner is aired in the prayer column of the petition. And it is about one petition which reads as next one. Learned counsel for the petitioner submits that miscellaneous appeal number 17 of 2023 has been kept pending for very long, and right to speedy remedy being a facet of Article 21 of the Constitution of India, long pendency needs to be abhorred, be held to or abhorred. First of he justified in saying that. Next, the circumstances, petition is disposed rare if possible. Petition is disposed of, directing the OP number,
Sole OP melody.
for directing the OP to hear and dispose of the subject appeal within an outer limit of 6 months. But all conditions. Next. You are for petitioner?
Yes, ma'am.
Next.
Submitted.
Ma'am, here the petition is praying for correction of date of birth, my lord. My lord, kindly see birth certificate, page 16, my lord.
In high school certificate?
High school certificate.
What is he doing now?
He is now unemployed. What happened, my lord? When his father was working as a Group D employee under Railway Department, after his expired, and his mother has got appointment on compassion ground. Thereafter, mother has expired due to cancer, my lord, in the year 2022. He is the only son, and there is no family member is looking to the petition. This son is 26 years old, my lord. When he has gone for compassionate appointment, thereafter the railway board has his date of birth was recorded in the high school certificate, my lord, 12th March 2000, my lord.
2000.
Railway board has said since his father was expired in the year 1998, how can he was born, my lord?
Correct.
Therefore, he came to know that after his query came to the petitioner and his neighbors came to know that his.
How neighbors? All they attended delivery of mother?
After he got the birth certificate, and the birth certificate is mentioned his date of birth 12/11/1997, my lord. 97, page 16, my lord.
Slowly. In the official records, it is 12/3/2000.
12/3/2000.
Is it correct?
12th in the HSC certificate.
HSC certificate. But the railway people say, how can his father give birth to a person?
His date of birth, actual.
My loaded senior.
It appears to be son.
His grievance is change in the birth date in the certificate. He passed the HSC in 5/5/2015.
Correct.
There is a restriction within 3 years he has to apply.
Is it? 3 years from which day?
From the publication of the result.
No, result even for date of birth.
Only for date of birth.
3-year limitation.
So,
what is a time bar it is. Whether limitation applies contrary to the fact, of course it can operate, is another thing.
that's a regulation.
My lord, as per your lordship in Jig.
Otherwise, Rao would have straightway agreed. Once I allow this petition, it becomes a precedent.
In Jignath Jadhav judgment, my lord, reported in year 2021, relying on that judgment in identical cases, this honorable court has passed a judgment. Sorry, my lord, only one copy is with me, my lord. I have not allowed. Here is 19 years after the date of birth, this honorable court relying on the judgment of Jignath Jadhav.
That is a different case.
After 19 years,
Take notice. Yes, I will take notice.
Let him correct.
Mr. All, the panel, senior panel will send the question to subnotice Bob. Who are the respondents? 1, 2, 3, 4.
Who is the only to my learned senior
Only two.
Yes, two.
Two. I am for the rest. Two. Okay. Mr. Ray is accept notice Bob. 1, 3, and 4. First one. Matter lies in another compass. Therefore, call this week after next.
Any short date, man.
We have some.
Today
Item 19.
I may pardon, my lord.
There is one judgment.
Item 17, I couldn't hear.
One judgment by Karnataka High Court which is affirmed by the Supreme Court. Krishnamurthy Rao, one state of Karnataka. Identical issue is decided as half in your favor, half in favor of Mr. Rao. By Karnataka High Court by Justice Raman Venkatachalaya, the great judge, decided that. Just look. It was under the determination, Karnataka Civil Services Determination of Age Act 1974. It's a different matter. This is not a service. Next.
Item 19.
I pardon, my lord. Item 17, I could not hear me.
17.
17.
Wait, there is a pendants. Huh? They are disposed of.
That has been disposed of.
What we have disposed of?
Disposed.
Tell how we have disposed.
Directed the subcollector, directed the subcollector to dispose of the miscellaneous appeal within a period of 6 months.
Disposed of within 6 months.
6 months.
4 weeks. Make it 4 weeks. Next.
Item 19.
In this street application, I will see a direction to the BT authority to issue the occupancy certificate.
Occupancy certificate does not issuing.
Madam,
They are not issuing.
they are issuing, but saying that the consent of the co-sharers is mandatory.
Consent of the co-sharer is mandatory. According to you, what is the legal position?
Legal position, settled principle law is that one of the co-sharers without consent sell the property.
Undivided share.
Madam,
Sold undivided share. But take notice, let us see notice. Because divergent, Bombay High Court said one thing, Allahabad High Court said another. Issue emergent notice, raise, accepted, request
For 1 and 2.
1 and 2, emergent notice.
To BDM.
Matter lies in a narrow compass. There is a conflicting, there are conflicting decisions on the issue involved. First, petitioner to make research and come back. Yes.
Item 20.
Wait, Mr. Lordship. Your Lordship, the matter relates to the correction of date of birth in the HSC examination certificate, which is issued by the. Sorry, Lordship?
Date of birth.
Yes, Your Lordship.
There, this matter was there before this honorable court. Your lordships have directed an inquiry to be conducted and some decision has to be taken. And the inquiry was conducted. The inquiry report says that the date of birth recorded is correct as per the records, as per the information given, as per the tabulation register. And therefore, we couldn't. What do you say?
Your Lordship may kindly. Lordship?
You go for suit.
Your Lordship may kindly say page 28.
28.
Last paragraph. I'm reading the relevant portion. The date of birth mentioned in original pass certificate issued by the BSc Orissa of Sri Prithviraj Manik is same as recorded in the admission register of Government UP School Tertang and TC issued by Government UP School Tertang and in the admission register of Government High School Darjang. At the time of inquiry at the Government UP School Tertang, the headmaster could not show the documents of Sri Prithviraj Manik which were submitted by his father at the time of admission of the petitioner. Your Lordship may kindly say Annexure 1, which is the certificate of birth of the petitioner. Page number 11. The date of birth is recorded as 9/11/2006. But the date of registration is 15/11/2006, which has been wrongly recorded as the date of birth of the petitioner in the certificate during the admission.
Date of birth is 9/11/2006.
And
Registered on 15/11/2006,
which is wrongly recorded as the date of birth.
The registration is treated as date of birth.
No, it was wrongly recorded by the headmaster.
I'm asking you. There are two dates. One
Yes, Your
is
Lordship.
birth date.
Yes, Your
Another is
Lordship.
registration of the birth date.
Yes, Your Lordship.
Now, what is the confusion?
The confusion is
Registration
that-
date has become the birth date.
Yes, Your Lordship.
What do you say, Mr. Rao? Even in such cases?
No, the problem is in the register, it was entered as birth information given by them.
Correct.
In the government schools. Now, in the certificate is in consonance with that, in accordance with the.
No, they are showing
Yes.
that unless you doubt this certificate itself.
No, I am not there. Whatever date of birth they have given at the time of admission in the school, that in the government school.
Within 3 years.
Yes, Your Lordship.
The rule of 3 years applies here.
Yes, Your Lordship.
Then you have to do this. Unless you doubt this, or unless you make an extraordinary case where interference of the court cannot be granted.
No, I quite understand my lord, but the problem is.
You have now the birth certificate is before me. Birth certificate is generated under the provisions of the 1964 Act of some
Registration of birth sentence act.
So, although what is stated in the birth certificate is not a gospel truth, still it carries very high presumptive value because of 3 decisions of the apex court.
There is no quarrel there, man. Absolutely.
But at the entry level, some mistakes
Your
happen.
Lordships are correct. But your Lordship will now see the difficulty. In the school register, one date of birth will be there. In the tabulation register, the same date of birth.
No, all that will be
Everything is
there.
there.
I understand.
Only in the
I quite see
certificate
that.
level. Inconsistent documents.
Your Lordship.
No, one second. What your authorities have said as to why they should not act upon the birth certificate?
That this is what the detailed order was given at your Lordship, Annexer 11, page 28.
No, they have not doubted the authenticity of the birth certificate.
Yes.
Then they have to act upon it. The pre-council said, if a birth certificate or some certificate generated under law, because at that time very old registration of births, deaths and marriages act was there, I think 1800, so and so. Then a new act has come into force. The pre-council decided that matter under the old act. They said, although what is stated in this certificate is not gospel truth, these certificates carry presumptive value. You can add.
No, but just regulation has been quoted at page 29.
29. What it says?
Rule 29, Rule 39.
The date of birth once entered in the board's records cannot be changed
unless it is of the nature of clerical error or printing mistake.
This is like even constitutional, you will not find such provisions in the constitution. Article 368. Why do you permit 368 in the constitution? They may disfigure, defile the constitution. But Ambedkar said in Bhandarkar Institute at Pune, if they want to do it, let them do. Courts are there to look after. If constitution can be amended, it's illogical to say that birth certificate and birth dates will not be entered. School certificate, school. There are other implications where service register, etc. I can understand where the apex court said because it will affect the career prospects, etc. But this is a school. You can amend the constitution, but you cannot amend the school register. I do not understand the comparative value system.
Well,
there may be consequences.
The difficulties will be like this. The school register is maintained by the government school, in the government school. Tabulation register is entered there as per the information given by them.
Correct.
Now, late on the day after more than 2.5 years, they come forward with a birth certificate and say that ultimate certificate is to be changed. There will be inconsistent documents in the field. Any complication may arise in future. In government school, entry is there.
Kindly read text of the rule. This rule is promulgated under which act? Under which?
Secondary education.
Secondary education. Which gives power to
make the powers to make regulations, and with regulation it is there.
The building blocks of this regulation which you are now faced, Rule 39. Kindly see the building blocks. If that means only clerical date of birth will be always arithmetic. It's like 152 of CPC. 152 of CPC. If you read literally, then no relief can be granted to any litigant at all. Courts are there to find out what really the rule maker wants to say.
Your lordships have seen me. I don't.
No, I'm not. I have great respect for you.
I don't stand on technicalities at all.
No, mine is a jurisprudential question.
Yes,
not personal question to Rao at all, whom I hold in very high esteem.
That's right. What I'm trying to say is, when on the field, two inconsistent documents are allowed to exist, unless there is a declaration. Your lordships, it fell from your lordships.
No, even if she goes to court, we will quote this rule. So sending her from Caesar to Caesar's side is useless.
I can quite understand that, but the question is, unless those documents are also corrected, inconsistent documents will be on the field. That's what my grievance, my anxiety. Suppose she produces the certificate duly corrected, whatever the correction directed, and places before some authority, and somebody produces the government record, where the tabulation register records in the school.
No, they cannot produce.
They will be different.
No, they will be different. But Supreme Court says HSC certificate should be acted upon for the purpose of date of birth.
Quite different other purposes.
That's all not substitutes. Take a look. Can you be seated? In the school record. First one. The counsel for the petitioner submits that some confusion having cropped up because of date of registration of birth as reflected in the date of, as wrongly reflected in the, reflected as the date of birth in the birth certificate, come on. How you have structured the sentence? Read the sentence. You have to be loud. You are reading it to me. Having crop. As wrongly reflected in the birth certificate. In the place of date of birth, that the date of birth is a very important factor in matters of education, employment, and the like. And therefore, whenever a mistake is pointed out, the jurisdictional authorities, such as school personnel, are to effect changes, keeping in view the public evidentiary material like the certificate of the person. She also tells the court that the apex court, in a catena of decisions, has held that the date of birth reflected in the HSC certificate is to be ordinarily taken as authentic. First up, so contending, she seeks to falter the impugned order dated.
Order dated in lordship of
T10,
2025.
An exact
11.
11. Next one. Learned senior counsel, Mr. Rao, appearing for the board.
Yes, Board of Secondary.
Board of Secondary Education, Mr. A.C. appearing for
Rest of the opposite parties.
Rest of the OPs. Resist the petition. 4 and 5. You are a 4 and 5? 4 and 5. Resist the petition, heavily placing reliance on Rule 39 of which
regulation of the regulation of the board.
What is the title of the? I have to write for you.
Regulation of board of Board of Secondary Education Regulation.
Extent board regulations. First, he submits that the subject board regulation has its own building blocks which limit the right to get the rectification. Kindly be seated also. Rectification. And in the absence of a challenge to the rule, the rule has to be taken with its literal meaning. First off, he also highlights the consequences of permitting belated claims for change of birth. In addition to pointing out that the conflicting records of other officials. Next, having heard the learned counsel for the parties and having perused the petition paper, this court is inclined to grant indulgence in the matter, broadly agreeing with the submission of learned counsel appearing for the petitioner. First up, mistakes do occur everywhere. There should be some mechanism for rectifying the mistake, unless the rectification itself breeds mischief, notwithstanding its truthfulness. First of all, keeping this in view, let me examine the text of Rule 37 and 39. Reproduce it. Next paragraph. Essentially, Rule 39 empowers rectification of date of birth. Of course, subject to certain qualifications and conditions. Qualifications, conditions, and limitations. First, one of the limitations is the limitation period of 3 years. First time, that has been prescribed, keeping in view the accumulated wisdom gained throughout by the officials, by the authorities. And therefore, in that matter, there cannot be any concession. As rightly contended by Mr. Rao. First. That being said, the rejection of petitioner's request for rectification of the date of birth is not on the ground of limitation period. And therefore, a deeper examination of the other jurisprudential blocks of the rule in question to be undertaken. Next paragraph. What we are interpreting is a delegated legislation and not a statute of Westminster Abbey. Rules the kind are meant for easing the lives of students and candidates, and not for perpetuating the difficulties by clinging on to the demonstrable mistakes. To err is human, said the sages centuries ago. And errors do occur when parents in our society report the date of birth of their wards while admitting them to the schools. First off, it is precisely for that reason the rule of the kind is promulgated. First off, Therefore, while construing such a rule, litera legis approach cannot be ordinarily had. First, what one has to see is the purposive theory of construction, which Aaron Barak of Israeli Supreme Court writes in his famous book, The Purposive Construction of the Purposive Construction of Statutes, something like that, just to look into from my notes. Next paragraph. There is no dispute as to the authenticity of the birth certificate, registration of the birth certificate. Dated 19/4/2025. No, not dated. The extract is dated 19/4/2025. It's a birth extract. But register will be with them.
Yes.
Whoever applies today, he will be given certificate. So date of certificate is different. Birth extract, first off. A perusal of the certificate shows that the date of registration of birth is 15/11/2006 and the date of birth is 9/11/2006. 9/11/2006. Where the mistake occurred?
Your Lordship, at the time of admission, the headmaster.
No, which date to be entered now?
The correct
Date of birth has to be entered.
Yes, Your Lordship, 9/11.
At the time of admission, the date of registration of birth is given instead of date of birth itself. The time difference being 6 days. 6 days. First off, it hardly needs to be stated that date of birth is one thing and date of registration of birth is another. Mistaking one for the other is disastrous. First of all, this aspect of the matter has not animated the impugned order, which reflects a bureaucratic approach designed to trouble the citizen. First off, next paragraph. Thus, there is error apparent on the face of the record, warranting indulgence of this court to do justice, for which writ courts do exist. First off, a worthy litigant cannot be sent back by quoting some jurisprudence case. First, next, in the above circumstances, petition succeeds. The writ of certiorari issues quashing the impugned order dated
3/10/25.
at an exact
11.
First off, the writ of mandamus issues to OP number
4 and 5.
2 and 5 together.
4 and 5.
4 and 5.
4 and 5.
One will hold token, one will hold pen. One should do it now. Who should do that?
4.
OP number 4. To rectify the mistake in the records, errors in the records.
Your Lordships may also issue a mandamus to 6, OP number 6, the headmaster, who has to correct his records also.
6, sorry.
4 and 6.
In terms of the birth certificate dated, birth extract dated 25, you said some date?
19/4/25, Annexure 1.
No. 19/4/2025, copy whereof Annexure 1. First off, this to be done within 4 weeks, 6 weeks.
No, it will be, she has to approach the headmaster.
Again.
No. Your lordship have given a direction.
Correct.
It has to route it through that. The provision is like this. No change in the date of birth recorded shall be made unless the application for correction.
That should be forwarded by this one, that so and so in headmaster. The OP number 6 shall take all steps to facilitate implementation of this order at the hands of OP number 4. OP number 4. First off, petitioner to cooperate and coordinate by producing necessary records, documents, as may be sought for accomplishing the task. Okay? How
This judgment will help so many candidates. This judgment will help so many candidates.
It should help actually. Now, how this rule is interpreted by my brother, sister judges? You have not done any research? Should have done. Just go research, do some research material, bring here. I will reflect it in my judgment. Okay? I will also say that you have argued very well.
Much obliged.
Item 21. Don't print it till rulings are placed at your hands. Okay?
21 is with regard to pension of block grant employees, your lordship. It's covered by Hemant Kumar Chotrai, and similar matter your lordship has issued notice also.
No, notice is issued?
Yes, yes.
Yeah. Issue notice, Ray accepts notice for 1 and 2, emergent notice to 3. Call this matter along with the WP number.
I don't have that number.
But you said similar matter.
It is similar to item 9 also.
Item number 9?
Today's item 9.
Call along with 9. Okay. When you say similar matter, you should have in your hands a copy of that order. At least some name, WP number, name of the party, name of the judge who decided the matter, date of the judgment.
Hemant Kumar Chotrai case is called.
Item 22. Yes.
There is a 25 ground force, sir. Ground force. That.
What is your prayer, sir?
4 of the judgment is false, as it is not material in the eye of law. So, the petitioner successfully invites the court to show that Robin Pani, the opposite party number 3, has been falsely filed his WS without to annex with the WS the certified copy of the order safety of the loan estimate canal to investigate the offense of the GR case number 459 by the other show and the loan additional district judge Dhekana of Srimati Anjali Pari without inquiry the certified copy of the order safety of the loan estimate canal has been falsely pronounced in her judgment by point 4 that opposite party number 3 Robin Pani has been investigated.
Can you take notice?
Yes, that's what only one. Yes, GR case number 459 by the show, which is such a judgment is wrong and illegal as it is taking the question of law. So, sir,
will issue notice now.
Sir,
I am agreeable with you. I agree with you. You argued very well now. We issue notice.
That's the only one question.
Yes.
Without inquiry, the order city of the loan examination, Robin Pani falsely stated in his WS that he has inquired the GR case number 459 by 4 and with her false WS, the loan exam Srimati Anjali Pari falsely pronounced that he had been investigated. The question is that Robin Pani is required to investigate the order safety of the loan examination. Nothing else. This is the question of law.
Yes.
To frame this issue.
Yes. We'll issue notice to the other side.
No. The Honorable Court may ask to Robin Pani to hold out means show the order safety of the Yes, law investigation में ढंका
Heard,
in order to investigate the case.
heard the
This is the question.
appearing for the petitioner. He made impressive arguments and made out a case for issuance of emergent. Issue emergent. Yes, sir.
Item 23.
The petitioner belongs to Kandha community, my lord. The presidential order 1950, article 42, my lord, page 9, annexure 1 series, page 9, reflect as 22, Kandha community.
You want a caste certificate?
Yes, my lord. I apply, my lord.
To you.
My lord, previously I also got my lord caste certificate, annexure 2, page 12, my lord.
Without insisting recommendation of?
Kui Samaj, this is the local body, my lord.
Local body?
Yes, my lord.
Local means corporation.
No, my lord.
But local body is defined that way.
Panchayat level, my lord. Kui Samaj, my lord. This name is Kui Samaj.
Kui Samaj.
Yes.
They are insisting upon that certificate from recommendation from that Samaj.
Yes, my lord. That is illegal, my lord.
You should understand, no? It should be question and answer. So that I can understand you. You can understand perhaps me also. See, while issuing caste certificate, your case is, you should not insist upon production of recommendation certificate by some private body.
Yes.
That's your case. They are insisting upon that recommendation.
My case
so recommendation चाहते हैं.
My case is, my lord, the Tahsildar is the competent authority, my lord.
Correct. What is his case?
Lordship, he having the previous certificate, my lord, page 12, my lord.
Correct.
And in the present, my lord, it is premature because of, my lord, page 13, lordship, kindly see, my lord.
1-3.
1-3, my lord.
Why premature?
Well, premature he has applied on, my lord, para 3, my lord, number and date, receiving application fees of the designated officer, my lord. That is on 15/10/2025. And my lord, then I am indulging my lord's attention. Para 6.
Scheduled tribe certificate.
Lordship.
Scheduled tribe certificate.
Yes. That will take 1 month time, my lord, and they have given the time.
What he is saying is, perhaps rightly, the Tahsildar cannot say.
Lordship, that is
that he is raising.
His preparation is applied. He approached this honorable court prematurely, my lord.
Why?
Because
he has applied now. He totally understand.
Lordship.
He has applied for the certificate. Tahsildar will say, produce a recommendation from your society, some body, etc. Unless your rules say, I cannot be at the mercy of some private body. Is contention.
He having no authority.
Right. Because he may not vote for the community, something like that. He says, I cannot be at the mercy of some private body.
Lordship. They may have a pick and choose, my lord.
Pick and choose they may do. They may seek money, arguably. I'm not saying that they will do. It's possible. If you marry my daughter, I will give certificate, otherwise I will not give you. Such things may happen.
Yes, ma'am. I am not disputing, my lord.
You take notice, emergent notice.
Lordship.
My lord, previously also got, I have inquiry.
Now I am ordering emergent notice. Let him reply so that the truth will come out. Any interim order you are sought for? No.
No, my lord.
No. Issue emergent notice. Mr. Ray, then the AC requested to accept notice for office. First of matter lies in a narrow path. Call the same in the first week of December, second week of December.
First week of no. My lord, done. Sorry, just first week of December. Yes.
First week. First week, I am likely to be. Of course, there are other judges. First week of December.
The caste certificate is necessary for the study of higher education, my lord. For my.
When it is admission? March?
No.
March, April, na?
Yes.
Yeah. Next.
Item 24.
Yes, that's fine.
Yes. But the petitioner is a state cadre teacher. His online application for second time mutual transfer has been rejected, applying that clause 2L. In similar
matters, we said that clause is not, it is excluded, na?
Yes.
when the transfer order is dated 14/5.
Yes.
But now we cannot issue an interim order because 5 months.
No interim order. Your lordship may only issue notice and your lordship may fix a date.
ASC is requested to accept notice for.
All the opposite parties will serve copy.
Hello, please. Call this matter along with WP 25305 of 2025. Bit early, since matter lies in a narrow compass.
Your lordship may fix a date. In that case, date has not been fixed.
Call these matters along with WP number so and so in the second week of December.
Second week of December. Connected matter is same.
Yeah, same. You read the other day, they have this class of employees
yes,
they excluded from.
Yes. I argued that.
Yes.
Item 25.
May I please, my lord?
Yes.
Here, my lord, the present petitioner, he has been working since last 13 years, my lord, as a part-time instructor, my lord. That is
Direction for renewing the engagement.
Here, my lord, what happened, my lord?
No, I'm asking you. What you have written, I'm asking.
Yes.
Your prayer is for renewing the engagement.
And questioning the, my lord, order, my lord.
Officer order dated. Hey, ask your registry not to put the seal on the date. Why your registry is putting seal on the date?
Here, my lord, what happened? Here, my lord, the petitioner, they're working as a part-time instructor. They're discharging as a teacher, my lord. And they're
both level officers.
But my lord, my case is, my lord, that they're appointed through open advertisement, my lord, as a part-time instructor, my lord. And since 2013, they're continuing, my lord. Here, what happened, my lord?
Mr. Behra.
My lord.
Read para 2. They think that they are still East India Company officials.
My lord.
Kindly read.
My lord,
Deputy Commissioner is not a queen of Katak. See the kind of write-up. Instead of submitting your grievance through proper channel, we have adopted your own sweet will in the matter and prefer to approach Collector and District Magistrate Katak in this regard. In such ignore the authority of Headmaster. Headmaster is not Governor General. She went to the District Magistrate. He went to District Magistrate. You could have said, no, brother, you have to come through proper
channel.
But the tenor of the order, the language of the order, it only reminds me of British Raj. They are all servants. We are all servants. Judges, lawyers, officials. We are all servants of the people. We are not their master. And she says, you have adopted argumentative attitude. Suppose if you give that reasoning, what they should do? You take notice. Emergent notice. Returnable within 2 weeks.
Allowed to continue, my lord, this.
When you were discontinued?
My lord, they have.
I am asking the date.
Date, my lord, impugned order is 19. 19. My tenure completed on 39. They have renewed the
others
on 29. My lord, annexure, I'm saying.
My lord,
2910, my lord. 2910.
Mr. Behra.
2910.
Annexure 10.
2910.
9/10/25.
That is later dated, but it has been scheduled to be held on 2910, my lord. I have mentioned in para 12, my lord.
2910.
Yes, my lord. That day they have renewed others.
My lord, his representation is pending. Your lord.
With this stage,
my lord,
I don't have confidence that they will do justice to this person. Issue emergent notice. First of all, learned counsel appearing for the petition. Mr. Behra is requested to accept notice for OPs. First of all, next paragraph. Learned counsel for the petitioner draws attention of the court to the pungent language employed in the impugned order dated 9/10/2025, a copy whereof awaits at Annexure 10. First off, he also states that the text spills venom, and that would not augur well to a welfare governance. First off, he also tells that other similarly circumstanced persons are being re-engaged and therefore an interim direction being issued to continue the petitioners in re-engage. How many? One petitioner.
Here, my lord, two cases, two petitioners.
What your reason? Should be appointed petitioners in service with same terms and conditions. First of all, although Mr. Behera apparently opposes.
My lord, it is allowing the petition.
But next we can decide that. Till next date.
Man.
Yes. Otherwise, the officers they think something more. Mr. Behera, learned AGA Mr. Behera opposes the interim prayer, contending that the grant of interim prayer would tantamount to granting final prayer. First of all, I do not subscribe to that view. That view. First of all, the very breadwinning of the petitioner sees at stake, and they are apparently poor people. First of all, heavens will not fall down if the petitioners are re-engaged during the pendency of some petition, especially when other similarly circumstanced candidates are being re-engaged with effect from 2910.
My lord, that effect from 110.
With effect from are re-engaged with effect from 110/2025. First of all, there will be no justification for having a stepmotherly attitude for the petitioners at the hands of answering OPs. First of all, this reasoning broadly accords with the decision of the apex court in Volga Tellis versus Greater Bombay Corporation, Mr. 1982, something like that, where it is observed that taking away the means of livelihood amounts to taking away the life itself. First, next, in the above circumstances, OPs are directed to which OP?
Collect OP2, my lord.
OP number 2 is that hereby directed to continue the petitioners by way of re-engagement with effect from 110/2025 with same terms and conditions during the pendency of this petition.
My lords, 110, there was a direction to re-engage. That is not the date from which.
With effect from which you tell me.
19, my lord.
No, 111.
19, my lord.
How 19? You are not there at all.
My lord.
From this day, we'll say.
Yes, my lord. My lord.
Immediately from this.
Lord, both the
non-implementation of this interim order may result into striking off the defense of the other side.
Both the cases, my lord.
Both the cases same,
my lord.
Your colleague he is.
So, my lord, we are watching, my lord. I was secretary, vice president of the bar. Therefore, any lawyer asks me to come, I used to come. That is my problem.
Next. Same order.
Same order.
Item 26.
Lordship, matter related to the appointment under rehabilitation assistance scheme. So, my lord, next order
of application. Okay.
Rehabilitation assistance scheme. Appointment under rehabilitation assistance scheme, my lords. Annexure 7 is pending before opposite. That may be disposed of, keeping in view of the annexure 6, my lords. Annexure 6 is.
Short grievance of the petitioner is against the pendency of his application for appointment by way of an uncompassionate ground. First of all, counsel for the petitioner draws attention of the court to representation dated 30/4/2025 at Annexure 7, wherein a request is made to the commissioner cum secretary to accord appointment of the kind. Keeping in view the recommendation dated.
Keeping in view of the notification annexure 6 minus. Keeping clause 2 last
dated 4/4/2025 at annexure 6. More particularly paragraph.
Clause 2B, last portion, in case death of the government.
Sorry, 1 second, you have to take the court along.
Slow to my lords. In case death of government employee prior to commencement of Odisha Civil Service Assistance duty shall be bedeled in on the basis of city.
But if someone bring someone to control you, to me also. Yes. Paragraph. You say following paragraph. Of that order. That is paragraph 2B. 2B. Just see that paragraph. Page number 22. 28. Okay. Just structure that. Next paragraph. Mr. Behra, the DG on request appearing for the OPs, very fairly submits that if petitioner also cooperates, by producing necessary documents and records, there would be no difficulty for considering the subject representation, even keeping the above notification in view. First of all, this is appreciable. Do you want to say any other thing?
Here is the problem. After completion of all formalities, discharge certificate issue, DI of school recommend to the director of elementary, case of the petitioner to the director of elementary education. Annexure 2, my lord, annexure 2, my application. Last portion, page 50, discharge certificate was issued. Thereafter, my lord, DI of school recommended the case of the petitioner to the director of elementary education. Director of elementary, thereafter directed the DI of school.
My lords, kindly see annexure 3, page 17.
My lord, last portion, my lord, you lord, message. Xerox copy of the first page of service book of late Shiva Prasad. But service book is not available in the office of the BO Bharatpur. His father during his lifetime annexure 4, my lord. Number of representation has been submitted to traceable of the service book or recasting of service book. They have not done. Thereafter communication of
service book is not available. So simple sentence you can see. You need not be so much tense at all. Number one. The other point, how many of your family members are re-employed?
No one.
You can tell that to them.
They are assuring that after available of service book, your case will be considered.
13 years, my lord, it is 2012.
No, but how if service book is not available? Service book should be maintained by who? You do not know anything. Keep quiet. How service book he will maintain? He has already lost father, mother, etc. How you will expect the son, daughter, aspiring person?
Other points also.
I can understand. Those things I can understand. Then if we say this, it will not help. It will not be help. You accept notice and I will call this matter next week. Because all they have recommended, and if you ask these things, it is impossible for him to do it.
No,
better to deny.
My lords, what I submit, my lords, from 2012 it is 13 years, my lord.
No.
He has not taken any steps.
They're all good people.
My lords,
you are not giving deputy commissioners.
My lords,
you are giving pune, sweeper, etc.
My lords, the representation may be considered.
But you will not that consider. Will it happen properly without insisting upon service book? Other evidence you should look into. Do you agree with that?
My lords,
you take some instruction because it gives an impression somehow they have hell-bent upon not giving appointment. That appears. Maybe XYZ reasons.
My lords, negligent on the part of the petitioner.
That's there.
Otherwise, the commissioner will direct them to recast the service book. No, they will not.
Mr. Behra also points out that there is lapse and latches. There is a lapse and latch. There are lapse and latches on the part of the petitioner, and that also would come in the way of favorably entertaining his prayer. First, having so contended, he fairly agrees to instruct his official points, namely OP number.
OP number, district education officer, in case non-ability of the service book, district education officer authorized the block education officer to recast in case not traceable. 4 and 5.
Two circumstances are there.
Yes, ma'am.
The inspector, his official clients, namely OP numbers 2 and 5.
No, 4 and 5.
4 and 5. To look into the grievance of the petitioner, keeping in view the difficulty in producing the service register,
service book
of the deceased. How service book of the deceased? How children will know?
No, my lord. Your lordship may see running to 27 official communication. 27. Then
his father also requested for recasting service book earlier during his lifetime.
During his lifetime.
My lord.
Series of communication.
With the suggestion of this court in that in all cases, invariably, the production of service books cannot be insisted upon. However, the other required evidentiary material cannot be dispensed with. First off, this is understandable. Next paragraph. In the above circumstances, petition is disposed of. Directing the OP numbers 3 and 4. 3 and 4.
No. My representation to opposite party number 1.
Party number 1?
1. Commissioner. For consideration for appointment or rehabilitation schemes, madam. Problem is that.
Problem is with you, your advocacy. Directing. You give one more representation to these people. Or will that
my left DO is the appointing authority. So commissioner, he has to consider.
He will forward it to government. Government will lastly
appointing authority.
Earlier the DI of school was the appointing authority.
Now the jurisdictional authority is to consider the subject representation of the petitioner within a period of 6 weeks. Period of 6 weeks. First off, petitioner to produce all other evidentiary material except the service. Okay. All contentions kept over.
Those are required.
As are required. When lawyers, brother, there are youngsters, I am addressing them through you. Okay, like Lord Krishna addressed the world at large through Arjuna. That way I am making a request now. Whenever you argue, first thing you have to ascertain is whether judge is catching my words. That is communication. Bhagavan Rajneesh Osho says, 2 monologues do not make a dialogue. You will say your story, I will say my story. There is no matching at all. In the contract law, the doctrine of addendum, meeting of minds. Meeting of minds should happen. That is argument. Therefore, you have to ascertain whether the person to whom you are addressing, it may be your father, mother, spouse, children, postman, whether he is understanding what I am saying. And I have to ascertain that. He has understood, yes. Then we have to carry it forward to Y fact. What I should do. X itself he has not agreed first. You cannot go to Y at all. Therefore, on communication, we have to work. We all have to work. It's an art. Communication is an art where silence works more and anxiety creates problem. You should not have anxiety. Slowly we should. I am telling it not to you. I am telling it to the last benchers, the budding lawyers. You argued well. I understand. All right. See our Behra, we will put one arrow and keep quiet. Arrow causes a lot of penury. Correct point he will go. Even Mohanty is also there. Same. Yes.
In this case, the opposite panel of 3 Staff Selection Commission issued advertisement for different posts. The petitioner applied for trained graduate teacher, science minor, CBZ post minor.
CBZ
minor. The petition is challenging. What happened now? The petition is challenging the answer key provided by the staff selection vis-a-vis his answer given to certain questions. It's not the answer.
You are challenging the correctness of the answer.
My answer in respect of certain question number, my lord. Not all.
Which are the key answers, wrong key answers, according to you?
I have challenging along with supporting textbooks, my lord. I have annexed to the writ petition.
Sure.
That is being approved by the government, my lord.
We did that part.
You will also kindly see Annexure 4, my lord.
4,
my lord. Annexure 4.
Which question is key answer is wrong according to you?
41, page 41.
41.
My lord. Chemistry paper 73 question.
73
question, my lord. Question number.
One second.
My lord.
73. The metal that is extracted by the reduction method is,
as per the commission,
Algerium, na?
As per
Aluminium or Algerium?
My lord, as per commission answer, my lord, key answer, mercury, Hg, B is their answer.
Hg is mercury.
My answer is, I have given answer A, aluminium.
You are given aluminium. What the standard books say?
My standard books, my lord, kindly let's see, Annexure 8, page 51, my lord.
Chemistry part 1.
Part 1, textbook for class 12th, my lord. National Council of Educational Research and Training. NCRT, my lord.
Where is the answer?
Answer, my lord, page 52. That has been described, my lord. Electrolytic reduction of alumina. Likewise, my lord, 8-point extraction of alumina. And lastly, electrolysis of alumina. In this book, my lord, it has been stated that metal that is extracted by the reduction method is alumina, my lord. Similarly, in respect of other 2-3 questions, only 2 questions. In total, 3 questions I am telling.
How many marks?
3 questions, I will get 3 marks. But as they have not given marks, they have deducted 0.75 each.
The negative evaluation is there.
My lord.
Negative evaluation is also there.
0.25 for each question.
Each wrong question.
Each wrong question. So 0.75 they are deducted. If I will get 3.
Just Mr. Behra appears to
my lord's staff election, my friend.
You will accept it.
I will take the notice now in this case.
Thank you. So, that panel, the senior panel for the staff collection. Election Commission accepts notice, requested to accept notice for 3. 1 and 2, Mr. Behra. Next sentence, please. Let us see. Any interim
Interim your lordship direct to keep one for my lord. By 15th, they are going to fill up the post. On the
let them fill up, but let it be subject to outcome of the petition. Otherwise, we will be holding back their hands. Any selection and appointment may be subject to appointment to the post in question shall be subject to outcome of the petition. Matter lies in a narrow compass, all the same in the second week of December.
Copy of the paper book may be served.
Yeah, so give copy of because along with all documents. What is that you want to show?
Sub item permitted to withdraw. Another with matter is there, madam.
You want to withdraw?
W is now 3121 by 2025.
Even?
Madam, 31219 by 25.
Withdraw in terms of bills. Just connect that one.
Item 28.
That is done.
Maybe, yes, the matter relating to.
You can draw the mic to your level.
The matter relating to non-issuance of legal aid certificate, my lord. Thus, in this case, my lord, I am the adopted daughter of the Moister Panda. See, he expired in the year 2007, my lord. After that, I have filed one civil suit, my lord. The suit was ordered.
Was decreed?
Yes, my lord. The kindly have a glance on
the parties.
Yes, my lord.
Who were the parties to the suit?
Only I am the legal heir.
You are the legal heir.
Yes, my lord.
You that Varasarani Panda.
Yes, ma'am. Varasarani Panda. I will glance on
that decree.
Yes, my lord. For page 11, my lord, annexion 1.
Kindly read.
Yes, my lord. The decree declaring that the plaintiff is the only legal heir of the Maheshwar Panda, deceased.
This decree is not. Now, you want legal heir certificate?
Yes, my lord.
Yes. You have decree. Even when there is a decree, you want legal heir certificate. What for you want that? If there is a legal heir certificate is not given, you can go to suit. Is our version. Now you are already before the court. You have obtained the decree. Still, you want legal heir certificate. Why?
I am her adopted daughter, my lord.
In this, what you had stated, you said that adopted. Where are the issues? In that suit, issues were framed. They're where? You have not produced the judgment.
My lord, page 8, your lordship, mainly.
Page 8, 9, my lord.
This is between bank and 2 persons.
For adoption.
My lord. There is no declaration to that.
Declaration, remedies.
There is no declaration to that.
But courts have acted upon that. No declaration. You take notice, let him take notice because there is no declaration. All right, issue emergent notice. And to Behra, I requested to some notice for OP numbers 1 and 2. Matter lies in a narrow compass calling the second week of December. Okay. Yes.
Item 29.
Item 29. That CBSE matter, the lordship issued notice in similar matter. I have one small prayer. So far as the opposite party numbers 1 to 3 are concerned, I will serve notice on Mr. T.N. Patnaik.
Yes.
And so far as opposite party number 4 is concerned, I will take notice by speed post.
Emergent notice by speed post to OP number 4. Learned senior panel counsel, Mr. T.N. Patnaik is requested to accept notice for
1 to 3.
1, 2, and 3 also?
Yes.
3. Call this matter along with WP 30975 of 2025, correct?
Yes. Item
And that date is fixed.
no date has been fixed, Your Lordship. Fixed date.
That no date is fixed.
No date has been fixed.
Third week of December?
Third week of December. Item 33 also same.
33 same order. Yes.
Item 30.
Item 30, my lords. I want to pray for withdrawal of the application, but with liberty, my lords. As of now, the cause.
Why you not happy with this judge?
No, my lords. No, my lords. Our grievance has been already catered to, but
only the petitioner has moved a memo dated so and so. See, which reads as under. Next, but in view of the above, leave having been accorded, petition is disposed of as having been withdrawn with liberty as sought for.
Deeply obliged, my lords.
Next.
Item 31.
May I please? In this case, my lord, the petitioner, while working as assistant teacher in the district of Bargarh, my lord.
Your voice is not audible to me.
A notification has been issued, my lord, for inter-district transfer, my lord. So, according to that, I have applied for inter-district and for the condition, my lord, on inter-district transfer, one has to accept the water scenario. So, as this petitioner, my lord, is a lady teacher and is working about 20 kilometers away from his family, so he applied for that. That has been
for transfer,
inter-district transfer, my lord. So that has been considered and accepted, my lord. And the concerned order has been issued by the director, my lord. That is OP number 2, right? Annexure
8-10-25.
8-10-25, my lord.
Where is your name?
Pardon?
Where is the name of your client?
Client, my lord, that is page 21 of the petition. That is serial number 240.
Huh?
240. Serial number 240.
240.
240. Then, my lord, according to this order, I have been relieved from my current post. That is at Annexure 6, my lord. And that has been done by the block education officer, my lord. So
then what happened?
On 13th October, then I report to my new place, my lord, that is the district education officer, that's my lord, on 16th October. So he asked me to report to the BO, that is block development, but the BO, that is OP number 5, is not allowing since then to joining my.
Why, brother?
My lord, I'll take instruction. I'll take instruction.
The lady. If BO says, I will not, this was that.
No, that is not.
It is for something else.
No, my lords, that is not there.
I will call this matter day after.
Next week. Next week.
Telephone call.
Yes, my lord.
Why
Next
is
week.
not allowing the lady? There must be something. I will not say now.
No, my lord.
Meanwhile, if it...
Let me take instruction then.
Issue emergent notice. Learned AGM Mr. Behra is requested to accept notice for 125. Emergent notice to 6 by speed post. Call this matter next Monday. Since matter lies in a very narrow compass, since some elements of doubt in the mind of this court about the conduct of the BEO, call this matter Monday. You show this order to him. Well, meanwhile, he may, if he do, I know him how to take.
I finally, but your lordship is fixing a sorted, so that is live. Publish.
Item 32. May I please, your lordship? The petitioner is a student.
Mr. Behra.
My lord.
Some teachers have written letters to me. They have come to my residence. That some BEOs are harassing them. And the word harassing I am using with inverted commas. Just I am waiting for a case to come here.
My lord.
Okay.
May I please, your lords?
Yes.
The petitioner is a student, my lord. He passed a secondary school examination 2020 to 10th from Central Board of Secondary Education and got admission for senior school certificate examination. And he appeared in 2024 And in one chemistry paper, he secured 30 marks.
Notice.
My lord, what I humble the last date of filling up the form was over. When the petitioner going to filling up his form through online, my lord, he was met with an accident. And last date was over. This is the last chance for him.
Correct. But if accident happens, accident is not treated as act of God.
And previously he was suffering from jaundice, my lord.
Jaundice is also, it's act of bacteria. What is not act of God at all. If date is fixed, things have to happen that way.
Just future of the student mind.
That will be a ground for claiming compensation under the Motor Vehicles.
Not I'm claiming compensation only for
Motor Vehicles Act.
Last date was over, my lord, for a
correct
examination, my lord.
Correct. That is a ground for claiming. There is a famous book, Kemp on damages.
I'm not claiming damages.
Not here. You have to claim damages there.
My future will be, my lord.
Other loss of future. That's a ground.
Now here, your lordship, permit me to filling my form should be accepted, my lord.
How?
Last date was over, my lord.
What can be done? Nothing can be done. That is one of the grounds under the Motor Vehicles Act. Even Sarala Verma recognizes. Only thing is you have to hear me. If you don't want to hear, you have to learn the law.
I am hearing.
Because I sat on various branches of law in these 8 years. Therefore, I am telling you, there are many youngsters, etc. Kemp on damages is a famous book.
Only one chance may be allowed, my lord, to submit his form so that.
How can that be, brother? Petitioner is knocking at the doors of Supreme Court with the following prayer. First main prayer. Who are the OPs?
There's Central Board of Secondary Education.
Rao appears for that. Mr. Chief, Mr. Patnaik. Next prayer. The above prayer cannot be granted in as much as admittedly the last date is over. Notwithstanding that, the cause for delay is the vehicular accident. First, once the last date is fixed, court has no business to extend the said period in the absence of statutory enablement. And to this effect, law reports gallowed. First one. Next paragraph. The second reason for declining indulgence in the matter is that if the petitioner is prejudiced because of the vehicular accident in question, such a prejudice can be a ground for claiming compensation stroke damages. Under the provisions of Motor Vehicles Act 1988, as held by the Apex Court in a platinum decision. First, Kemp and damages treats this aspect of the matter. First, like in the above circumstances, petition being devoid of merits is liable to be and accordingly rejected in limine. Registry to send copy of this order to this by speed post immediately for their information and file. Not.
Item 33 has been adjourned. Item 34.
For discussion already, you have already decided the matters. The matters decided.
No, the stay has been granted on the recommendation of the MP and MLS transfer.
When the order is made, which date order?
This order is not.
No, order of transfer.
23rd. Same day, 23rd.
G. We are getting all those matters posted now here.
Yes, my lord.
That I have given. Today, my lord, item 71. My lord, make a mention at 2 p.m.
Very good.
My lord, lordship, kindly have a look to annexure 2 of this order. They are saying that they are, yes.
pursuant to the notification that, page 12, my lord, page 12. Pursuant to the notification number so-and-so dated so-and-so, issued by the Government of Odisha School and Mass Education, Memo Director Secondary Education Odisha, on rectification of the district level transfer committee in the meeting held on 25/9/2025 under the chairmanship of Collector and District Magistrate Puri, the following secondary teachers are hereby transferred and posted to act as. Here there is no question of, here there is no question, my lord, there is no question and whisper about the MPMLS instruction, my lord. So my lord, the lordship may kindly bear with me that the transfer order was issued by the appropriate authority. After rationalizing, they have done it. On the basis of rationalization, administrative grounds, the detail present in below.
I will hear you. I will not dismiss without hearing you. Kindly sit down. Sit down, because he gets embarrassed. You are interfering all through.
My lord,
that disturbs me also. Yes.
My lord, they are hereby transferred and posted to act as such in their own scale of pay in the schools as mentioned against each on the basis of rationalization and administrative grounds. The details of the present posting of the schools to which he or she is posted on transfer.
General transfer.
My lord. It's a general.
Single sporadic transfer at the instance of.
No, it's a general transfer, my lord.
That done what? During what period it is done?
My lord, it was done on 23/10/2025.
When the academic year ends?
Academic year ends in the month of April.
But why in the middle of the academic year?
It was a continuous process, my lord. They have applied through online. Thereafter, on basing on rationalization, that has been done. My lord, here the according to their Shilpi Bose's case, my lord, there is no malified at all.
That's all right. But the transfer season is when?
By 15th June.
15th June to
May to June.
Why in the middle?
Thereafter, the process was started and it was ended on 23/10. That's why.
You can't do that. Otherwise, every teacher has to maintain two houses, two families. One here, one there. How is it possible? That is the reason why you have prescribed the transfer season.
My lord.
This only reminds me of
this is what my lord.
Shakespeare's Rape of Lucrece.
Yes.
There one stanza read, "O opportunity, thy guilt is great. Thou settest that wolf where he may get the lamb. Thou settest the season for the commission of pleasure."
My lord.
So, season, where is the season? It exceeds the season now.
My lord, it is for the betterment of the students. It has
makes no sense. Every transfer has to be for betterment only.
My lord, where there are no teachers, we had sent them.
Is it your case?
My lord, it's a rationalization. That is rationalization.
Means what? Kindly be seated. Kindly be seated.
Rationalization means where there is lack of teachers, we are sending their teachers.
There are no teachers now?
No, my lord. There are lack of different subjects. There are teachers. Subject teachers are there. A matter of secondary schools means high schools, my lord.
Since how long subject teachers were not available?
Every year, my lord, they are retiring.
No, I am asking. Retirement is known to you well in advance.
Yes, but it takes time, my lord. Kindly bear with me, my lord, because suppose there is a recruitment advertisement was made. Advertisement was made for filling up the posts of teachers. 3 days, 4 days thereafter, my lord, an interim order was passed by your lordships. This way, this bench, that bench, they are passing, my lord. So, to complete a process of recruitment, it takes years.
They will be without teachers.
My lord, what can we do, my lord?
You have created difficulty to me now. We are doing such mistakes actually. We are taking the appointment.
Lordship may kindly bear with me because I was told place. Anyway, Lordship may hear this matter along with 71 so that
everything
it will be better.
Yes, you want to say something? Your client is here.
I will be grateful, my lord. Your lordship kindly.
I will be grateful if you answer my question also.
My client is not here.
Not here. Okay. Then not.
Annexure 2 is the effect of Annexure 1. Your Lordship, kindly see this Annexure 1, page 8.
Annexure 1 is the principal order.
Annexure 1 is the same date.
23/10/2025.
Same date. 23/10/25. Pursuant to the order, last 3 lines, Your Lordship, see. Page 8. These transfers have been made on the basis of the recommendation so received from the MPs.
Honorable MLA's Puri district.
No, he is not. In this case, the name of the petitioner is not there.
In which?
In this annexure 1. Any annexure
C has been placed. This serial number 38 has been placed
because of that.
Yes.
Your case, Mr. G.
And that.
Therefore, he was in exile.
Chandpur.
Sure. We'll hear this matter today itself.
Today, 71 is there, and another batch of cases will come on 17th November.
Dispose of this matter today. We will duplicate that order in that also. You may win also here. We don't know.
No, my Lord, because our counter has not yet come.
Issue.
It is on the way.
Learned counsel for the petitioner vehemently submits that increased transfer is effected because of interference of local MLA stroke PS2 MLA. Because PS2 MLA has gone to that level now. MLA. And in a curtain of decision, in a curtain of cases, this court has already granted interim protection. First off, he submits that his client should be or entitled to be treated on par, and therefore they too are to be protected from untimely and unseasoned transfer. First off, there is force in this submission. Although Mr. G very passionately argued as to the absence of political interference, at this stage it cannot be accepted because the first paragraph of order at Annexure 1 itself mentions about MLAs and PS to MLAs. Really, it's a great first one. Next one in the verse. The impugned order to the extent it relates to the petitioner. Just how many? Only one petitioner is hereby stayed until further orders. Call this matter along with the other batch. Do you have our number?
20894.
Other day? 208. Today.
That is today.
Today.
As item number 71. Matters will come on 17th, those matters.
On 17th.
The batch matter is coming up.
Yes. Brother, I have a question to you. Why you assume that I will not hear you?
No, that is the anxiety only.
May I please, my lords?
Yes.
May I please, my lords? This is another transfer, Annexure 3, old widow lady, 58 years, less than 2 years service. She has been transferred to a distance place under Annexure 3, my lord. That is by the DO. Page 16, my lord. Page 16, allow transfer. 58,
16,
my lord.
Your client is that?
Kalpana Satpathy. Last, and 6, serial number 6, my lord.
Kalpana Satpathy.
My lord. Transport distance place, less than 2 years service. After rule, 50 pension rule, my lords. She should not have transferred before 2 years. Only 1 year and 6 months left. And what widow lady, nobody is there to look up.
Are you saying widow lady? Can there be widow gents? Widow means lady only.
Yes, so that is it. And she is suffering. Kindly say that I have also earned the medical certificates.
Suffering from?
Suffering from a kindly page 13.
From page 13?
Page 13, the legs. Problem in the legs, knee. And it's 13, page 13. Kindly see.
What is this?
Problem is the leg for the notice.
notice, stay of impugned order till next date of hearing. Okay. She accepts notice for this. Next.
Item 36. The petitioner had filed his writ application for direction to the opposite party for release of arrear salary of the petitioner, and the Honorable Court dispose of the writ application directing the opposite party to dispose of the petitioner within 8 weeks. 8 weeks has been passed. They have not released the arrear salary of the petitioner.
Issue police notice to OPs. Returnable within 10 days. The OPs are directed to be personally present before the court on the next date of hearing, unless, however, presence will be dispensed with if they comply with the order. Registry to send a copy of this order by speed post. Speed post. Also, speed post also. Okay. I'll fix a date. Call this matter on. When? On that day. Okay.
Lordship adjourned to which state?
No, I'm not issuing notice to you. I'm issuing police notice to them. I'm not issuing. Private parties cannot be defended by government advocates because they will be taking our money. They should defend themselves now. Yes. Otherwise, I am saying, I'm sorry. I'm sorry.
Lordship.
Whole contempt law has to be resurrected now. Contempt by police. Yes.
Lordship adjourned to which state?
Date you can give 21st. Unofficially you can take that.
Yes, yes. None of it.
We have no duty.
No.
Yes.
I am confused.
I know 37.
21. 11. You just tell the officers.
Yes.
They will have difficult times in my court. Yes.
No, they should face. If somebody is not complying with your lordship's order,
complying.
Then, Lord, I'm
simply arrested.
I'm serious about that.
Simply arrested.
I'm serious about that.
Yes.
Item 37. I know 37.
Item 37?
37.
37. Minor 37.
Not 37.
Purely private issue. Money has been paid for purchase of plot and is not returning.
He is not returning.
And
action can be taken for that.
Approach to economic effect suing the police station.
Press vote OP number 1 to provide the land for which OP number 1 has taken money from the petitioner. You want more than a specific performance decree. How petition is maintainable, brother? Civil suit to be filed. I'm standing like the Rock of Gibraltar. You are standing like Rock of Gibraltar. Not even trembling.
Minor in the year 2011, I booked two plots from Umamani Home Creations.
How I can issue? It's a private dispute, no, brother.
Sir, till that, I also approached the offence wing, economic offence wing, but no action was taken. Till now, I have not got any money or any refund or plots from that Umamani Home Creations.
Petitioner has structured his prayer as under. First one. Next verse. The above prayers are essentially directed against private parties who do not have elements of public law duty. First one. The apex court in LIC of India versus Escorts Limited, 86 Supreme Court, says that unless the action is pregnant with elements of public law, writ remedy cannot be sought. First, in the opposite circumstances petition is disposed of, reserving liberty to the petitioner to approach the appropriate forum like the civil court, etc., for working out his remedies in accordance with law. First of all contentions in that result. Next. One matter you can. I came very late today. 10 minutes extra. You can say. Yes.
Item 38, may I please your lordship? My lord, I am in BC, my lord.
Yes, sir.
My lord, the area salary of the petitioners, your lordship, has already issued notice, and only the issue is, my lord, on the form plea of allotment of funds, they have not given paid the area salary, my lord. Although the project was closed and we are terminated from service on closure of the project, but our salary is due and admissible as per the prayer, my lord, that was not given. Even though several letters were wrote to the authority, my lord, Annexer 6 is also our representation, and they have also, as per Annexer 7, recommended for allotment of funds, but that was not given, my lord. Since 2023, my lord.
Recommended by whom?
Recommended by the OUT authority, my lord, that they are admitting that their claims is to be genuine and they are to be paid, my lord. For a particular project for 3 years, we have been appointed, my lord.
Annexer 6 now.
6 is the representation, my lord.
They have given the representation that money is due. They have put service.
Yes,
they have put in service.
Yes, admittedly, they are entitled to the salary. We also don't dispute that. I have received the counter to that extent. So what has happened? Well, this is a central funding project. We have also written to the Ministry of Human Resources that
they have not done anything.
Yes, my lord.
Whom you have implemented? OPs?
If you implement, my lord, the
OPs, who are the OPs?
Ministry of Science and Government of India. And
who appears for the science and technology?
Normally,
yes. Whether notice was sent to him?
He is not party here, my lord. That's the
brother, you make the central ministry a party to this. I will direct you to implead. You need not make application. I am directing to implead.
I will file counter by tomorrow. Our stand is that they are entitled to.
But your stand is unless they pay, we are not.
That is our problem, man.
The senior panel counsel appearing for the
my simple panel count.
Panel counsel. OP number 1.
1 and 2.
1 and 2. Very fairly submits that although the amount claimed in the petition arguably is payable by his client, there is difficulty in as much as that money has to come from central fund.
Yes.
More particularly, which
Department of Biotechnology, Minister of Science and Technology.
Department of Biotechnology, Ministry of Science and Technology, New Delhi. First time. He also points out that in the absence of the said department as a party to the petition, it may be difficult for the court to adjudicate the claim.
Yes.
First off, at this stage, learned counsel for the petitioner submits that a direction be issued for arraying the said department as OP number 3. First off. Next one, in the above circumstances, the petitioner is directed to array the department of so as OP number 3 immediately. First, learned ASG, Mr. So is requested to accept notice for the said OP, newly added OP. Petitioner to serve copy of the petition along with all the documents on the learned AST.
My lord, is the government of
India.
That is government of India.
You serve copy on AST.
My lord.
Sir,
DSGI.
Sorry.
Your lordship, I will file by tomorrow. Your lordship, list it on next Monday.
Perhaps my friend is here, he can add he can
My
add.
lord, my associate is there, he can correct the
No, he gave up Mr. Sahu. He is an VC, perhaps he is the associate of Mr. Sahu can
do the needful.
Yes, he can carry out the
Petitioner to accomplish the formal requirements. Okay. Call this matter on 18th.
My lord.
1811.
Published.
Hey, any difficulty? You are a bit reluctant. Sahu. Mr. Sahu was reluctant when I said the date. Do you want any other date?
18 is no, my lord. No, my lord. 18 is okay, my lord. I am agreeing.
In the meanwhile, yes, the counter may be filed. Whosoever desires.
Yes, by tomorrow.
Obliged, man. Highly obliged.
Item 39.
I was from a company which had hired a transporter to transport my fabric rolls.
What fabric?
Fabric rolls from Chennai to Noida. I hired 2 trucks. In one of the trucks, they were supplying cannabis, ganja. That truck was seized. My fabric rolls were also seized. I filed for release of the fabric rolls. I came before this Hon'Ble Court in criminal revision back in the year 2020. This court asked me to furnish bank guarantee for release of the fabric rolls. I furnished a bank guarantee of 45 lakhs. Price of the fabric rolls. My fabric rolls were released. The order stated that after the conclusion of the trial, I may be allowed to take my fabric rolls.
Subject to outcome of the trial. Yeah, you were not an accused.
I was never the accused. Neither I was charge sheeted nor my name is there in the trial. There was 4 accused. One was absconding, for which the trial was split. Against 3 accused, trial has been concluded. They have been acquitted.
Split trial.
Split trial. And another accused is still absconding. Year after year, I am renewing my bank guarantee. I am only here to...
You furnish property.
I took instructions from the client. They are willing to furnish a personal bond if that is
Personal bond, what to do?
Personal bond,
death occurs. How to enforce the bond? That is the reason
the properties, your lordship, are invested in other things.
Yeah,
or something. So that can be
true. Even if it's a foreign property, if you give it by way of security, we will do whatever we want.
Or your lordship, if you can ask someone else who is connected to the company, maybe he can furnish his personal bond and surety, property surety.
No, because death when it knocks my door.
Property, but not belonging to the company, will that suffice? That
any immovable property
that we can do,
which is free from any cloud.
Any person can furnish. We can do that. We can do that.
If you do it over, because you people, police people will not go chasing absconding people. So how long he can go on, because every time he makes the bank guarantee,
the renewal price
incurs expenditure.
Your worship, can you see cost title, page 2? No department has been mentioned, only state of Odisha.
But anyway, you are representing. See, you give full description of Mr. Lenka here. Give that description.
He wants release of the direction to whom? Even prayer.
The bank guarantee has been furnished to the lower court, your lordship.
The court has to be. Concerned court has to.
You have to make an application to the court.
Yes.
We'll tell the court to release your fabric cloth. Fabric cloth.
Rolls.
Fabric rolls. Subject to furnishing the immovable property of the value to the satisfaction of them.
But not mandatorily belonging to the company.
Yeah, anybody, I will say that.
That would be.
Why company does not have property?
It's mortgaged in some other places. They are not willing to.
Regardless of text and context of the prayer, the essential grievance of the petitioner is as to the insistence of the court below to renew the bank guarantee by way of security for the fabric rolls, kindly be seated, which have been released under section 451 CRPC, perhaps it is.
457.
It may not be 457.
451, so yes.
Under the provisions of section 451 of CRPC 1973, as it then was. The prosecution having been launched under the narcotics. Next paragraph. Counsel for the petitioner submits that there were 4 accused persons, and the case having been split, 3 have been tried and acquitted. Whereas the 4th one has been absconding person. Eventually, counsel submits, his client is incurring heavy loss, heavy expenditure for securing the renewal of bank guarantee, which is not done freely. First of all, he very submits that his client or anyone on behalf of his client would furnish a reasonable immobile property by way of security instead of renewal of the bank guarantee. First off, this proposal is innocuous and acceptable to this court. Next one, in the above circumstances, this petition is disposed of, permitting the petitioner to make an appropriate application to the court below in what is that case? No particulars in the prayer, brother. Court below. And if such an application is moved, the court below shall allow the same, keeping the above observations. First,
Your Lordship, TR number 12 of 2020.
TR 12 of 2020. Pending on the court of?
Sessions Judge come Special Judge Korapur.
Pending in the court of Learned Sessions Judge Korapur District. Korapur. Okay? That's the right time. All right, this will help you. This will help.
Much obliged.
Can I come after?
Pursuant to Lordship's order dated 1310, valid affidavit shown by the Secretary of Orissa and the Chancellor on behalf of the Chancellor regarding the vacancy in elementary and secondary education.
I have also filed an additional affidavit enclosing 2 of the documents.
And one thing more, my lord, regarding vacancy.
Make use of mic. Let people hear. These are matters where public at large is interested.
Yes, sir.
Though it is individual in nature, people should know. how government works, how officers work, how judges work, how government lawyers work, private lawyers also. Therefore, take use of the mic.
So far it relates to filling of vacancy in university. Another PIL has been filed and a notice has been issued.
No problem. Is for filing also.
That I have brought.
May I submit?
One second. You want to say something?
Only that I want to brought to your kind notice that
whether PIL was filed earlier or my order was made earlier.
PIL filed earlier.
Order of the PIL was made when? Which date?
22nd September 2025.
Okay, when I made the order?
1310.
1310. Okay. So many subsequent. PIL is also for
only for universities.
University.
But here you will have title elementary, secondary, higher secondary, and higher education.
College.
One second. Mr. Lenka.
Yes, sir.
We'll keep that the PIL aspect aside now because matter is being looked into by Honorable the Chief Justice. I don't want to.
But we have
given that also
information.
That's good.
The vacant position.
How many posts are vacant?
Yes. Your Lordship may kindly.
Now come to Directorate of Elementary Education.
Yes, sir.
How many posts are sanctioned? How many are filled up?
Your Lordship may kindly see page 2, paragraph 2.
Page 2, para 2.
Sanction strength. Elementary teacher. Your Lordship got that?
Yes, 1,35,656 is the sanctioned strength.
Yes.
Of them, 1,18,683 is working now.
Then vacant post is
53,561 vacancies.
Yes.
Why they are not filled up?
That we have.
One by one we'll go.
Yes.
This is a Director of Elementary Education.
Yes.
Just my notes I will make.
Yes.
Mr. Lenka has filed the affidavit.
I have filed.
You also filed.
Filed in additional affidavit.
Do you dispute his version?
Yes. That version, that their document I have filed. One more, only before my lord technically change the rule.
Read.
Section 26 of that right to free and compulsory education. Central Act. Filling of the vacancies of the teachers.
Yes.
The appointing authority.
They should make all arrangements for making the.
No. There is a point. Just I'm reading out my lord. 2 lines. The appointing authority in relation to a school established, owned, controlled, or substantially financed by funds provided directly or indirectly by the appropriate government or by a local authority shall ensure that vacancy of teachers in a school under its control shall not exceed 10% of the total sanctioned strength. This is important. Vacancy cannot go beyond exceed 10%. If you accept,
I'm asking, why vacancy should be there?
Yes, my lord. Yeah, at least if the statute says the statute says it cannot go beyond 40%. No, sorry, 10%. Now, if my lord noting my lord, that's
I have fully understood. There is nothing new which you are saying.
That
Then you Lordship has taken them.
1 second. Mr. Lenka has filed an affidavit sworn to by the Chief Secretary.
Yes.
Chief Secretary, Government of Orissa, Bhubaneswar.
And another
1 second.
sentence.
At the para 2,
Yes.
there is a table which gives full particulars of employment of elementary teachers. Elementary education. Teachers in elementary education.
Yes, sir.
All categories. First off, the sanctioned strength of teachers in the state is 1,35,656. First off. Of them, 1,18,683 teachers have been appointed. First off, the vacancy position as on this day is 53,561. Which section, Dash, you mentioned?
26.
Section 26 of RTE Act prescribes that the vacancy position shall not exceed 10% of the sanctioned strength. Then go to next paragraph.
Yes. Paragraph 3.
This is
regarding higher secondary education. Then next page, page 3. There are 3 categories. One, government
higher secondary,
then the school, then non-government aided, then block grant. So government higher secondary sanctioned 1734.
No. 1734 is sanctioned. 291 is filled. 1443 vacancy. 54 vacancy. 242. The total vacancy position is 1,739.
50%. Almost. Almost 50%.
40% plus. Right?
No, 50%.
50% plus.
3,500, 1,700, almost.
Yes. Then
you actually kind of do
government high schools.
Yes.
5,565.
Yes.
That also again much more than 10%.
Yes.
Then no, 10% is, it is the parliament is unhappy. It says, we understand you are all incapable people, therefore we will not fill up the vacancies. Even then, you cannot keep the vacancies beyond 10% of the sanction strength. With the no joy in heart, Parliament is saying that. Parliament is not saying you maintain 10% vacancy. It is tolerating the states for not making 10% vacancy. So I have understood now. Go to para 5.
Yes. Para 5 high schools.
And even their vacancy position is 13,260.
Yes.
See in that Sanskrit, in Sanskrit 739 vacancies and 237 are working. This is the way the Sanskrit and the Sanskriti are treated. Dr. Ambedkar said in 1949, September, Sanskrit should be language, national language of this country. At least 2 Chief Justices of this court, they have mentioned about this. Retired Chief Justices of India said about this, what Dr. Ambedkar had said. Just see the Google. There, 739 sanction strength, working strength is 237. And Sanskrit is a scheduled language. Go to 8th schedule of the Constitution. And Will Durant writes in History of Civilization, 11-volume work. Will Durant, Ariel Durant, they write in that book, in the 2nd volume, Our Oriental Heritage. They write, Sanskrit is the mother of languages. India is the mother of all countries, all nations. And this is the way you are treating this language. And your Oriya, which is my Oriya also, it has
from the beginning
abundant Sanskrit words, abundant. Because that is the reason why I understand. If somebody reads I cannot read. I should learn to read is another thing which I will do. Whenever your bar members read, I fully understand that.
Yes.
To a large extent, I understand. Because it contains Sanskrit words only. So, in new aided high schools, 5,538 vacancy.
Yes. Then fully aided 1,655, like previous page. And government high school, 5,560.
But you have put the board, this time that board was removed. I don't know why you have removed. But for the first time when I came, there was a board which says government is generating employment opportunities to the people. What generating? All vacancies being kept unfilled. And this time board was not there in the report.
It was put by the previous government. Now it has been removed and another scheme, Dixit Bharat scheme.
How Bharat will
because that is scheme.
How that
in the affidavit he has mentioned that. Your Lordship.
Now you tell me how you are going to fill up these vacancies. Where you are filling up the vacancies?
Paragraph 13 of my affidavit.
1.3.
Yes.
No, exactly.
Paragraph 13, page 9.
3. Because I am saying, Mr. Lenka, I tell you, lot of unemployment problem is in this state.
Yes.
Huge section is downtrodden, very huge section. SCs and STs. Many youths are unemployed. They don't have anything. Many of the cases that come before me, peon, teacher, headmaster is the highest post which I am treating here. Sweepers, attenders, group 1, group 2, group 3. I'm not speaking of class 1, class 2, class 3. Group 1, group 2, group 3, group 4 also. These are the cases which I have been handling. I'm just keeping an eye on the nature of jobs which people aspire here. Why these vacancies are kept? They become age barred also. Age barring happens.
That is a constant.
Tomorrow you will call for application. All are age barred.
No, we have
relaxed.
42 years.
42 years.
Not a great.
You make it 50.
The limit now
59.
52.
You make it 50
59.
so that to 50 they can apply.
No, we have already done 42.
Therefore, I am telling you, make it 52. Maybe 59 also. What is the age of the
60. So let it 59. That I am suggesting.
Make it 59. That helps them. 1 year they will serve. That is not the object of a welfare state. The object of the welfare state is also to generate employment. Now you can't say that you have not generated. Because you have already created the force. You have sanctioned the force. And you have made some appointments. Other appointments are yet to be made. When are you going to make this appointment? I will really tell you, I am son of this soil also. We are all sons and daughters of Lord Jagannath. We cannot just ritualistically do my judgeship and go away. I will not go that way. I have to repay the debt in this land, which treats me with so much love and affection. I have to do something for the youths, something for the unemployed people. The court is a shareholder. It is a shareholder in all that is happening. We will not decide cases between A versus B. Mr. Swain will argue, Mr. Lenka will argue, all they will go. No, that is not my object. How you are going to fill up these vacancies? How are you going to satisfy our youths? Our youths are without job. Or you abolish all these posts. We don't need so many teachers at all. All they will go for fishing. Children will go for fishing. That's nice actually. Fishing is a great job.
Your Lordship may kindly see paragraph 13.
1.3.
Yes. This affidavit has been shown by Chief Secretary of Odisha that the process of filling up
remaining vacancies underway. What is remaining vacancies? Existing vacancies. Existing, not remaining. Means other vacancies. Remaining has a different meaning. Anyway.
Underway and expected to be completed progressively during 25-26 academic session. Subject to recruitment agency timelines and judicial outcome. Because some cases are pending.
G has mentioned.
Yes.
No issue. We'll come to that also.
And also SLP is pending in Supreme Court also.
Whether SLP said don't appoint anybody?
No.
No.
Then appoint. subject to outcome of the SLP.
Your Lordship.
Where is how SLP will come in the way?
Then sub judice, my lord.
What sub judice?
Annexer D, your Lordship.
Unless the court holds your hands, you should act.
If your Lordship will go, there are some cases where
I can understand.
So far, Annexer D, if your Lordship will go to see, will see that so far the universities are concerned, there are Supreme Court cases pending before the Honorable Supreme Court.
No, that is over. That is cases. Kindly sit down.
Well,
Mr. Dash, kindly sit down. You are disturbing the court. Brother Linka.
Yes, sir.
How many cases are pending before the apex court? In how many cases apex court said don't appoint? Show that.
What has not
show one single order where the apex court has come in the way of your making appointment.
But in our own High Court some stay.
Well, leave them. Yes. Wherever there is High Court stay,
yes, sir.
You leave them. Wherever there is no stay, where is the statistical data? Kindly see, para 13. Such a serious matter, your secretary, chief secretary answers para 13. This is the full answer. That the process of filling up remaining vacancies is underway. Means what? Underway. What is meant by that? Underway means file is moving from one table to another. I want to know. Expected to be completed progressively. See, the word's terminology is wonderful.
Page 21, Your Lordship.
What have you done?
Your Lordship, can you see page 21?
And why it was not done all these years?
That's
who are responsible?
We have explained. Page 21. Last but one para. The Honorable Apex Court.
In so.
Yes. By hearing the matter, as an interim measure, stayed the operation of the interim judgment that was passed by the Honorable High Court of Orissa. That is also pending.
Stayed the operation of the impugned judgment. What is that judgment? That judgment said appoint, Supreme Court stayed. Is it so? What is that case about? Who are the parties? What is the stage of the proceedings? What action you have taken to vacate the stay?
May I please paragraph, page 19, para 2, last. From that, Your Lordship will.
Yes, 19. Mr. Lenka,
yes, sir.
You have to tell me which are those cases, what are the orders made in those cases. We will not touch them. If the apex court says no, we will not touch them. But you have to show that apex court has come in the way of making recruitment, appointment, filling the vacancy. How can apex court be? How apex court will never because section says there are at least 2 judgments of the apex court which says an ideal government should not keep the vacancies unfilled.
7520 they've set it so. The apex court has clarified that. Case 23 may kindly see. Apex court has clarified on 7525 that you go with the recruitment as per the new amendment act. Page 23 of that affidavit.
What 23?
Yes, as per the Honorable Supreme Court while hearing the aforesaid SLP. I will clarify what is SLP, but kindly read now. No. The affidavit Mr. Lenka is showing from that page 23.
Permit the state to proceed with recruitment.
Yes.
It is your affidavit, Mr. Lenka.
Yes.
That time so.
This order was made when?
7525.
How many months have elapsed now? Mr. Lenka, I have to file a better or
these are only vacancy position, Your Lordship wanted. We
wanted to know what are the actions you have taken for all that vacancy. What I should do with the statistical data? I cannot bake them for preparing pani puri. I want this statistical data because our youths are suffering without job. We are not saying make up all appointments of all youths. We are saying whatever vacancies are there. Mr. G, you have to assist here also. Yeah. G and Lenka, both you have to assist this matter collectively. See, vacancy position is spoken now.
Yes.
Sanction strength, working strength.
Yes.
It is minus the vacancy position has come. Vacancy position Mr. Lenka has given.
Well,
your chief secretary says the para
13.
13. Read it again. Let people see. I want all the people to see this. That the process of filling up remaining vacancies is underway means what? Underway means what? It is saying like in the pipeline will be 25 kilometers. That will not make sense. Expect it to be completed progressively during 25-26. Two questions. Why vacancies were not filled up even when the Central Act is operating? Section 26, yes, of the Act says there shall not be
vacancy less than 10%.
Why is that? Then I will make observation. The center should consider as to why funds should not be allotted to the state. Because parliamentary legislation, you are not respecting the parliament. I will pass an order saying central government should consider whether no fund should be allocated to state of Odisha. Let people revolt. Otherwise, no things will move in the state. Now you have to explain what is meant by progressively, what is meant by underway, what is meant by expected.
My lord, three things are there. But you may call this matter some other day so that.
Which date? You think I want some plan, action taken plans, not just statistics.
Lordship, call this matter.
Many youths have not married when I was coming. Just I was walking around.
I will explain. I
asked some youths came and greeted me.
Yes.
They were not that happy with judges anyway. With a smile they greeted. Now,
a week after, my lord, any day after week.
Yes, choose a date. On that day, Mr. Lenka, G, both they have to assist.
Yes. So, first week of December sometimes.
Oh, no, not December. December, Roses will be in December, not
will be in December.
26 Any day,
28. Yes. 28. Any problem with 18? Only we want this. What you have done? Let people know. That I want to tell the people. I may not pass the order also. I will tell government is working this way. Elections are around. Yes. I will tell the people that way.
28, my lord. 28, my lord.
28?
Yes.
Why so much time for giving what you have done based upon the records? What is that?
21st, my lord.
No, I am asking. I will give you, but what is so much time? These are all computer generated.
No, my lord, I am to see that entire records, my lord, so that I can have taken such a stand in the year so that I can appraise your lordships.
Then I will not pass any order today.
No.
Next date I will pass order with a pen dipped in acid.
My lord, yes.
This you should tell your chief secretary. You know, I cannot see Apex Court has said we should not call the officer secretaries. I understand that.
No, my lord. Lordship, I don't
that is not complete immunity.
My lord.
Otherwise, the constitutional court will fail in its duty. It's our duty.
Yes.
All youths wasting their life because of the government's inaction.
Only one line I will permit it, my lord. My case, the writ petition, what is the prayer, my lord? All these are unemployed, eligible. But the posts are now being filled up by these retired teachers. Those are not eligible. So now, my lord, the retired teachers.
One second. Why retired teachers? They are in the evening of their lives. They are valuable. You can understand. Where is the provision for appointing retired teachers in your recruitment rules? Number one. Why they should be appointed? They are getting their pension.
Yes.
They are happy in the evening of their lives. What should happen to the youths, young people? Why all this no brain?
Only for the interest of the students. Only for 6 months they have been.
Why you have not appointed?
Because it was.
No, it will not remain 6 months. Thereafter, again, court will grant stay against removal. Other court will stay the recruitment process itself.
No,
it generates
this matter on that day. I shall satisfy your lordship. Why?
What I
No appointments.
what no yes
No appointment of
Shall be made to the retired teachers.
no retired.
no guideline is
Retired teachers should be in the evening of their life.
up to my lords 1 minute only one more slide. Yes
You want
no, actually after one line I will leave him. Now on 20, I have challenged that order. Now on 23/10/25 again the Department of Higher Education is issued a guideline. I have given it today's affidavit to recruit retired professors, teachers. Even after my lord's order, that only I want to brought.
No, don't.
That is the problem. They issued a guideline.
But
No, I will not pass out. Sir, if you are sure, I will record it. Otherwise, I will direct personal presence of the secretary.
Stop gap arrangement because
Why should
the
that?
process will take time.
How much? Where is your plan of action? Timeline. Give me the timeline.
That you lordship be running on 21st.
21st.
21st. That
we shall satisfy you.
Yes. The chief secretary of the government of Odisha has sworn to an affidavit which is filed by learned AGA Mr. Lenka, giving substantial particulars expected under this court's order dated 13/10/2025. First off, when the vacancy position in all the sectors exceeds nearly 40-50% and in some cases 75%, 70%, this court does not find any plausible explanation for maintaining the same as it is. First off, like adding insult to the injury, the youths are not being appointed, but those who have retired from service and who have been in the evening of their life are sought to be engaged as teachers. First off, the educational institutions cannot run with the spent forces, more particularly when no provision of law is indicated to this court which authorizes re-engagement of retired teachers to the positions, without taking any initiative for filling the vacancies that are in thousands. Total vacancy will be how much?
we have given abstract.
Total vacancy. So just compute it.
Yes, yes.
Eligible and qualified youths are crying.
Paragraph page 8. I have not made total, but abstract has been given. Paragraph
That the employment opportunities are not being made available to them, though huge vacancies exist.
Around at 70,000. 77,000.
70,000.
53, 13,000, 53, 1984 and 4367. Except
compute that.
73, page 73,000 counter I have given to you.
69 probably.
The total vacancy position is above 73,000. This is a huge vacancy position.
Minus university.
This is excluding the vacancies that obtain in the universities. How many universities in the state?
13.
15.
13 universities.
15 universities.
15 universities. Are you sure?
Yes. 17. Actually, those two universities are deducted. State in,
No, not deemed university.
not deemed. 15 state universities.
How many universities, Mr. G?
Now 17.
17.
17 universities. Universities.
And for that, on behalf
What
of
is the vacancy
Chancellor,
position in the
yes,
universities?
yes, sir. The university paragraph, you lordship will see,
Wherein vacancy position
Yes,
in
sir.
all
page 6, right?
cadres.
Page
is
6, paragraph 6, page 6.
How many? Totally how much?
Total is, I have not made totals. Around 4,000.
Around 5,000.
About not less than 5,000.
About approximately 5,000.
Nearly 5,000. Wherein vacancy is nearly 5,000. First, Mr. Lenka and Mr. G submit that they would come out with full facts, figures, and figures, and also the concrete plan of action for filling these vacancies. First off, Mr. Lenka points out that in respect of vacancies obtaining in the universities, PIL is pending for the first court.
PIL number, WPC
number?
WPC 22591 by 2025. Praveen Kumar Das was
of 2025. Be that as it may, since the object of PIL is also to ensure recruitment. Okay.
And one thing, Your Lordship, on behalf of Chancellor, opposite party 9, the affidavit has also filed.
Chancellor also has filed?
Yes. And the same.
Chancellor is a university, governor is the chancellor.
Yes.
What is the affidavit?
Same. What we have stated in Chief Secretary's affidavit, he has also
stated. Perhaps you have given the information and affidavit is shown to be the, so generally principal secretary to government, somebody will find.
Because Your Lordship implemented Chancellor.
Chancellor is going to answer. Chancellor is not exempted from there is no immunity to the Chancellor. Immunity is to the governor.
And Your Lordship will find the Honorable Governor had held a meeting on 3rd 11 after Your Lordship's order, along with all the Vice Chancellors.
That we have very really appreciable.
That we have also mentioned in Chancellor's affidavit.
Where is that page?
Yes, ma'am. I'm telling you.
9, para 9.
Yes.
Mr. Renka, drawing attention of the court to paragraph 9 of the affidavit filed by, sworn to by Commissioner cum Secretary to Chancellor, submits that
higher education.
The governor himself being the chancellor of all the universities under the state, in the state, all the universities?
Yes.
State universities.
All the state universities in the state.
Not private.
Come on. A meeting has been held on 3/11/2025 in the shadow of, under the shadow of the order dated 13/10/2025 made by this court. And the steps are being taken on a war footing to fill up the vacancies in the said universities. This is really appreciable. First off, however, why all these months, if not years, these vacancies have been kept unfilled remains a mystery wrapped in enigma. First of all, much is not necessary to say. Okay. Next date, Mr. G, you have to come first with the plan of action. This is a fraud on the youths of the state. Fraud on the youth.
Sir, Your Lordship's order passed.
Yeah, I have passed.
And I have pursued the matter time and again. And state has taken cognizance seriously.
The effective steps taken by Learned Counsel, Learned EGA, Mr. Lenka, and Mr. Learned EGA in the matter of seminal importance is appreciated, deeply appreciated. Okay. But next time, Mr. Lanka, Mr. G, something should happen. Immunity is to the governor, not to the chancellor. I am repeating, this is what the apex court has said. That famous judgment. I forgot that the Bihar state, which is that judgment? Immunity is to the governor, not to the chancellor. Because we work under the constitution. There is no complete immunity at all. Therefore, it should be brought to the notice of Honorable the Chancellor of the universities that this is the legal position, which is the 2002 Supreme Court, which is that 2003? Huh? No. There's another judgment.
Kuntes Gupta.
Huh? This is where they have decided the powers of the governor, no? And structure that judgment. Call on 21st.
This Dr. Kuntes Gupta versus management of Hindu.
No.
No. There is the power in this time.
That.
If the Honorable Court permits, my lords, we have filed an interlocutory application for intervention. It hasn't been tagged up with the main writ application.
Let us, you be here, you also assist. Let us.
My lords, I only pray the intervention application may be tagged up at the next meeting.
Registry to post all pending IAS. Next date of hearing.
Item 41. The petition which is a trained graduate teacher, my lord. That is available the benefit on 1196 and till 28 to 2004. But all of
96 to 2004.
2004. My lord, while he was
retired on?
My lord?
When he retired?
Not during pendency of the writ application. That the my lord, I am
asking a question.
Written in 21.
Yes, you should answer the court's question.
Yes, madam. That is during such the availability of the TG post and availability scale of pay up to 2004. That he was under the urban local body, my lord. Thereafter,
you should listen to the judge.
Man.
You are arguing like one-way traffic. I don't understand.
No, sorry, man.
Yes, brother, what happened?
Lord and friend, challenge the rejection order, my lord. I am appearing for the except, my lord. 5 all the opposite parties.
Who is the decision maker?
Initially appointed under the urban local body, my lord, that is housing and urban development.
Now who is the appointing authority?
And I presently the school and mass education department. Lordship.
Why they have not done? How many years they have served? How many more judgments we should had? Already we have rendered so many judgments. Keeping those judgments in your mind, you should take the decision. Where is that reflection?
Yeah, approach the Honorable Court, my lord. The Honorable Court, basing upon the judgment, Arthatran Bag versus State of Orissa, in OA number 12, 15 number 93, decided this. My lord, kindly have a glance, page 87 of my brief. That is 87. 87.
Go to 87.
Paragraph 5 of the judgment of the Honorable Court. They specifically directed to take a decision in this regard.
You have told me to read, I am reading.
Yes, ma'am.
You should permit me to read, na? Or you read, I will listen to that. Taken over by the school.
Ma'am.
Are you ready in the matter?
Lordship, the first time government notice has not been issued.
First time it is.
It is first time. The last time my learned senior is not there. Lordship.
The same is requested for some notice. ACC is requested also notice for the OP numbers 1, 2, 3, 4. No. 1, 2, 3.
1, 2, 3. 1, 2, 3.
1, 2, 3, 4. Correct. 6 and 7. Emergent notice to 5.
Emergent notice to 5.
1, 2, 3, 4, 6 and 7 you are appearing. All right, let's move on. Item 42?
Item 42, my lord.
Yeah.
My lord, he said date, my lord, at least a retired teacher, my lord. Why are getting this?
The second week of December.
Item 42, my lord. This is regarding selection of trained graduate teacher, science, my lord, CBZ, my lord.
My
lord. In this case, what are opposite panel 3 issued advertisement for the said post, my lord. I have applied, the petitioner applied for the said post. In this case, petitioner challenging one question, my lord, of the key answer given by the staff selection commission. On the ground that
take notice.
File
objection.
I have already filed my objection and they has already filed a rejoinder to that one also. Nothing is otherwise.
We can.
Your lordship had directed me even to bring some textbooks in this contest, my lord. So,
what was the question?
That is with respect to the question is that, my lord, this is the last now.
Make use of the mic. Your voice is weak. Which question?
The last.
Page 49. Read
Can I have a short adjournment at your hands? I have to read this file and I'll come back after reading. Right. This method. 17, how many methods are there?
17, 10 methods.
Put it on 17th.
17th,
yes.
In the first order, my lord, your lordship, in one matter of mine, item 27, the lordship directed any appointment subject to outcome.
Same appointments. Selection and appointment shall be subject to outcome of the petition. Even otherwise, list pendants. Section 52 of the Transfer of Property Act that operates even in service jurisprudence. Yes. Item 43.
Well, pursuant to earlier order of this Hon'Ble Court, my claim has been rejected under Annexure 16. Annexure 16.
Page number.
Not there.
Therefore, I ask him page number.
Annexure 11. Annexure 11, page 86.
86. What is your
my regularization from the initial date of appointment has been rejected. Your lordship may issue notice because my ground is on Amarkant Rai.
You have already held with effect from the date of entry. You have to regularize the services.
But my name cannot be, no, my lord, my name may not be reflected. Mr. Mahanti's name may be reflected.
Okay. You don't have to.
No.
But how many states of Orissa are there in this state?
Look,
and we see the caste
no. One is Department of School and Mass Education.
How many states you are in free? This should put secretary.
One is
Odisha. We have been taught that.
That's right.
Unless you
second one is the ought to have been Secretary Law Department.
Secretary.
That I have.
Otherwise, it may trigger splitting moment.
Yes.
That's very Mr. Mahanti is requested to accept requested to accept notice for Advocate General also.
Because at present I am continuing Advocate. Earlier I was under School and Mass.
These 3 peons were working under me when I was there in the Department of School and Mass.
4 extra copies I will start.
We give copies.
4 extra copies.
You need 4 copies. Whichever copies you have necessary.
LMS, 1 copy is there, 4 copies. LMS is there, it can be utilized.
All right.
Next. 44.
May it please your lordship.
Yes.
Mine is an application for restitution of WPC 12970, which are dismissed.
Voice is not clear. Yes.
Here, my lord, on 2 occasions, on 18/6 and 24/6, while the matter is in the board, because of the non-prosecution, matter has been dismissed. Subsequently, they have filed one application. So instead of that nomenclature of CMAPL, they have filed this application as IA. So it has been wrongly, that is subsequently.
Dismiss for default is a bad thing to happen in the court. Why we should
That
discuss
barely-
that thousands of cases are pending here. Why to discuss as if we have to sit without any cases? Not like that. I'll recall that order. You give, sir, you give one good book to your library. Whether your client is, can he afford to do that? Is he a poor man?
If your lordship orders, what can
No, not like that. I will not order unless you.
Sir, actually, there is no delay.
No delay.
I was filed inadvertently, and immediately after disposal of the IA, with the door
The bench of this court by order dated 24/6/2025 had dismissed the petition for non-prosecution. First time. The applications are moved, one for the condonation of delay and another for its restoration. Delay, counsel for the petitioner submits is not there. First time. Assuming that there is a delay, in matters like this, the same has to be viewed leniently. First time. After all, if the request is allowed, what would happen is that the matter would be restored to the court and shall be heard on merits. First time, if application is heard on merits, and thus no prejudice would be caused to anyone. First time. Conversely, if the request for restoration is denied, then it is end of the matter, regardless of the merits thereof. First off, non-prosecution is not a happy thing to happen at the hands of the constitutional court when so many matters are pending for consideration. First off. Next time, it is not that the case would have been heard and finally decided in the court if it was not dismissed for non-prosecution. The papers would have been languishing in the court cupboard without seeing a ray of light. Right. First time. Next, in the above circumstances, applications are allowed. First time, the arguable delay is condoned. First time, the impugned order dated 24/6/2025 having been recalled, the matter is restored. Main matter is restored to the board for consideration of question. What you have to do? Any compliance is to be. Either you are not there because of that absence or what? Non-prosecution is what?
Non-prosecution to in absence of the lawyer. So it will be restored to file and the fresh matter is to be listed.
Okay. Post this matter. When do you want, sir?
It's possible because it is true.
I'm sorry that matter was wrongly dismissed. This much I
No, sir.
When do you want this matter?
It's possible.
In third week of December? Okay, third week of December.
December, my lord?
Third week of, all right, on 27th of this month?
Yes.
Okay, 27.
Obliged.
Okay.
Item 45.
But in this case, I am praying to time to comply with your lordship's last order that I will produce the copy of the order passed earlier in favor of the opposite party number 7, by which my lord he has got a land.
OP number 7, how he got the allotment? Show that.
My lord?
Order dated 13th and 25th.
To comply that order, I am seeking time.
Yes, who should comply?
Yeah. order earlier order opposite party number 7 रे हितला.
अच्छा.
तापर
P numbers 2 and 4. You have been granted the request of the petitioner. 2, 3, 4 and 6. But however, it mentions the petitioner to produce.
Yes, I will produce. For that reason, my lord, I am unable to produce today.
Okay.
That's why I am seeking time.
When do you want?
Yes, sir. I'm also suffering from fever. That's why my Malayalam sister is.
But you don't look to be suffering from it. You will cause fever to my sister.
My lord,
When do you want?
difficult.
Huh?
I got myself in difficulty because of the stay order. Yes.
Short adjournment.
Last time also.
So how?
He will not get the land, my lord. Ultimately, the matter will be had.
Let us have this matter on 26th. We can have.
Yes, ma'am.
My lord, can I pray on 25th?
25th?
On that day again, my lord, I will ask for time.
No, ask for I will not grant time merely for asking.
No, sister, the reason, best reason I will also give.
Let us see.
Pleading already completed.
Reason is already in the manufacturing process now.
You know, I am also ill, my lord. I am also ill, my lord, suffering from cold and cough.
Not well. Get well then. I'll give whichever date you want.
She was 26, it may be 26, my lord.
25.
It is a Wednesday.
Wednesday. Oh, no, we'll have it on
20
for you.
Tuesday.
Oh, we'll have it on 27th.
25th. May I pray on 25th?
Did you consult any astrologer today in the morning?
That day.
27.
That day, 25.
25th, interim order में kindly continue.
Interim order to continue.
अब interim order था
Till next day. Then interim order, that's okay.
Yes, ma'am, that is an interim order.
Yes. Yeah, it's there. It's there.
25th.
Yes, sir. Get well.
Item 46. Item 46.
I may be pardoned, my lords. I'm appearing virtually.
Yes. Wanted to withdraw.
We have permitted to withdraw, my lords. We have filed an IA for withdrawal, my lords.
Okay.
Deeply obliged, my lords.
Item 47.
Petition of paper withdraw. Permitted to withdraw.
Permitted to withdraw?
Yes, ma'am.
You filed at least in memo?
47.
Filed it? Same order. Next.
Item 48.
Yes, sir.
May I please, Your Lordship? Let's hear the petitioner is a company.
Make use of the mic.
Yes, please.
That mic also with you so that your voice will be audible to me.
Now let's hear the petitioner is a company that deals in establishing and running cold storage units.
Cold storage unit? Storage for?
For potatoes, ma'am.
Potatoes?
Yes, ma'am. Now he purchased a piece of land which was originally run by another cold storage unit who could not complete the construction and could not make it viable for the purposes of storage. So he purchased it from that particular Ma Tarini cold storage and intended to construct by installing latest equipments. Now a capital investment subsidy is granted to such cold storage units by virtue of the National Horticulture Mission and also the State Potato Mission, where a certain subsidy at the certain percentage of the project cost is forwarded to the beneficiary. Now, once this project is funded by a financial institution, this subsidy, in fact, goes to the financial institution for the purposes of liquidating the loan that is advanced. Suppose
which you have taken.
Which I have taken. Now, on perusal of everything, verification, I was granted loan by the bank. The bank forwarded all possible documents to the National Horticulture Board, who is responsible for the release. And everything was set in motion. I was granted the work order also. Now, subsequently, the work order was cancelled on the ground that the earlier cold storage unit.
What was the grant order?
Yes, my lord. Your lordship will kindly see.
Work order dated?
Yes, my lord. But the work order dated is page 37. Page 37, my lord, of the writ petition.
I want date.
It's 6th of February 2015.
Cancellation date?
Cancellation date is, my lord, the communication is on the 27th of February 2015. Now, the reason for cancellation was...
Who is the authority who passed the first order, who passed the second order?
That's the authority's Deputy Director of Horticulture.
What are his powers?
He is the sanctioning authority in the state, in the sense that the entire subsidy released by the center will come to the horticulture department in in Orissa, who will release it, my lords. That's the procedure.
Agency.
Yes.
Money belongs to the central government.
Yes. That is under the central mission. That's the National Horticulture Mission.
Is it relatable to any statute or only executive power of the state?
So it's executive power is what I've understood, because this is a policy under the central government to aid these cold storage units, because there is an acute shortage across the country.
Storage especially.
Yes, my lord. Because these are all perishable
goods.
Yes, my lord. Now, my lords, this cancellation, if your lordship sees, page 37 of the writ petition, for a moment.
That you have challenged here.
I'll come to that, my lords.
What is your challenge?
My challenge is that although I am entitled to a capital investment subsidy under the mission of the central government, as well as I'm eligible under the state potato mission, which is another state governed mission, I have not been disbursed any capital investment subsidy till date. That is the grievance.
It's on the ground that this is cancelled or independently?
No, but there's a subsequent development. Now, once this was cancelled, I wrote to the collector, who is one of the authorities forming a committee. He's the chairman of the district nodal committee, my lords. Now, he inquired into the matter by forming a technical joint committee. That committee opined that this cancellation is not proper because this has been done in undue haste. The mission, in fact, provides for grant of subsidy and it should be reconsidered. It was never reconsidered. In fact, there was a recommendation by the technical committee also, which I've annexed to the writ petition, wherein I'm entitled to a subsidy of 2 crores 10 lakhs. Now, nothing was done, so the writ petition was filed.
Who is your opponent?
Well, my opponent is the state.
Yes, Mr.
State is there.
But it's not ordered. First time it has come. No.
No, it's the pleadings are complete. Now, I'll just inform your lordship of the subsequent development.
No, I want to know whether they are drawing the battle lines or not.
Yes, ma'am.
Yes, brother.
Here, my lord, we have filed the counter.
Yes.
Answering all these points which has been agitated in the writ application.
On what grounds? You had admittedly you had issued the work order.
Yes, ma'am.
On what ground it has been recorded?
My lord, the sum and substance is the capital investment subsidy, which is to be released in favor of the petitioner as has been prayed. There are certain conditions to refund back that subsidy amount. So in fact, here also they have taken a stand that the subsidy has been released in favor of another cold storage, keeping in view, because when the matter is there for establishment of the, cold storage, so it has to be newly formed, newly constructed. For this purpose, this amount has been. But here the petitioner.
How the terminology of the policy?
Yes,
whether it says that way?
Yes, ma'am. Because earlier occasion, the same subsidy has been disbursed against the existing
from whom he has bought it.
Yes, ma'am. For that purpose, it could not be released because once it has been released against another
person,
not person, that institution, or it is cold storage. So the second time it cannot be.
What was it released to him?
Yes.
He made utilization of that money.
Matarani cold storage.
Did he make use of that?
Yes, ma'am. So this is a old one which has been renovated. But the purpose of using the fund is to establish a new one.
Whether policy is property specific or person specific?
Property specific.
Read that. Where is that policy? If it is property specific, he has no case. If it is person specific, arguably he has a case. What is your opinion on that?
May I clarify this?
Yes.
That's the original work order which was cancelled. That was on the premise that an amount of 23 lakhs odd has been disbursed in favor of
your seller, vendor.
Original is the vendor. So that was put to the committee by the collector, and the committee opined that the purpose of the very objective of the policy is that a new structure is to come up. Now, I have gone through the policy. What I've understood, the humble understanding is the reason for a new establishment or old establishment is not there. The intention is that a cold storage unit, for the purposes of being given the advantage of the subsidy, has to have the latest technology. Because my lord, huge amount is being disbursed.
Suppose if you had not bought it, whether your predecessor in title could have the benefit of this policy, that is the decision. That is the question. That would be the moot question. Because you are a buyer.
Yes.
You are more like respondents. You stand in his shoes. If he could now establish, if he could get this money, you are logically will be entitled to get it. If going by Mr. Mohanty's argument, if the original, that's your vendor could not have secured this, you cannot secure it.
No, vendor could have secured it.
That you have to establish.
That is admitted. That is not disputed. So the reason for rejection,
they have given that is all right.
Yes.
It's not a statutory order.
That's right.
You cannot go to Mohinder Singh Gill. Mohinder Singh
improving upon
point to improve statutory order. Therefore, I asked you whether it is a statutory decision. You said the executive decision.
It is, my lord, because
therefore we cannot strictly go by Mohinder Singh Gill at all.
So once you sanction the subsidy to the vendor in respect of the same cold storage unit, which has now been modernized and made fit to be utilized in terms of the policy objectives. Now, I have invested money by virtue of the financing by the bank to make it viable for the purposes of utilization in the modern terms, which is apropos to the objectives of the mission.
But did you, before making all this, did you bring it to the notice of those people?
Yes,
I am buying this property. I want to modernize, update it.
That was not
taking that.
That was not done.
Then how can you cast your obligation?
No, what has now happened, my lord, is that during the pendency of the writ petition, I took leave of this honorable court and made a representation to the concerned authority that you release the subsidy, which is the differential amount as per the opinion of the technical joint committee. Because the technical joint committee, which was formed by virtue of an order of the collector, is that since 23 lakhs odd has been disbursed, with interest, you deduct that from the total eligible amount of the present petitioner and you disburse it, because you can never come to the conclusion that I am not entitled to it.
Consider the representation.
They have considered.
Rejected.
They have rejected on the ground that there is an EOW case pending against me.
What is that?
That's an economic offense wing matter, which relates to Milad's misutilization of funds, public funds. Now, Milad, I have sought for I've annexed it to the writ petition by way of an amendment, wherein a clarification has come from the investigating officer that the subsidy which is released in favor of Ma Tarini has never been utilized by the petitioner. No subsidy has been given to the petitioner under the scheme, under the mission. So therefore, the pendency of an EOW proceeding, if any,
against your vendor,
against
yes. What happened to that? It's pending now.
That is pending.
Then you are, after what happens, they will take a decision and you withdraw petition and challenge it. Yes. The event, it goes against you. Otherwise, on that ground, I am dismissing the petition.
So that's why,
rightly or wrongly, you are not innocent man because you are arrayed as accused.
That's right, Milad. I cannot, Milad. That's the fact of the case.
Accused is also entitled to doctrine of innocence is one thing. That is for various purposes. But in matters like this, you get disposed of, you get that matter disposed of, and I will make observation. You cannot keep it endlessly pending.
Milad, that matter, Milad, in my humble submission is completely different as what is the report of the investigator. You'll actually see that document once.
No, report already. Call has to be taken by the magistrate, not by me. I am a High Court judge. I am not a magistrate.
So that's right. I'm not taking your lordship into that. But only if your lordship sees that document for a moment, that will clarify certain things.
How can I say, if a document is produced before the magistrate, magistrate has to take the call.
No, but this has got nothing to do with the merits of the EOW.
No, I do not agree with that. There are such judgments.
But in fact, here, there was an inquiry made. Information was sought for, saying that what is the role of the petitioner insofar as the subsidy is concerned. Whether the complaint under the let's emanate.
Agreed. You are an accused.
Listen, I'm yet to be Mulad's.
Wait. You are summoned now. There.
That's right.
When in criminal law, when the person against whom allegations are made becomes an accused, at what stage?
But here the charge sheet has been submitted. So
once that's what Hardeep Singh versus state, which is that judgment 2014. Hardeep Singh versus so and so. Once charges are framed, you are an accused. Filing of charge sheet may not be. Based upon the filing of charge sheet, which you call in your state, what we call it charge sheet, though that word is not used in CRPC.
Final form.
Final report. Is it not? Based on that, the court has to take a decision. Therefore, it is not if the court acquits it, well, it's not acquittal. Discharge. Because unless trial happens, no question of acquittal arises.
Obliged.
Therefore, as of now, there is a criminal case pending against you. What is your policy? What does the policy say? If any criminal case is, if he is involved in any criminal case, something, of course, even otherwise that we can
understand.
That is not there.
So far this sanction is concerned, I have a glance to page 15 to my counter. So it is term and conditions basing upon which this amount has been allowed and what are the basis. This will clarify the entire situation.
No, I am not on that. I want to cut short this petition because of the pendency of criminal case against the petitioner. If he emerges victorious there, you make application for discharge 227, 339, old CRPC, new CRPC, I do not know. If you make an application and if you are discharged, now it is at the stage of framing of charge. Because the report is filed. Court may not frame also, obviously. So, you withdraw this petition, I am suggesting. Otherwise, I am making that Hardeep Singh versus State of Punjab, 10 January 2020. This is citation, what is this? Yeah, AR 2014, sorry.
CC report.
No, AR 2014 SC 1400. It says, when a person becomes accused, merely because if you go and lodge a complaint against Mr. Mohanty will not become accused. Because anybody can lodge the complaint. By lodging complaint, by lodging FIR or a complaint under 200, nobody becomes the accused. That one argument is available to you. But at this stage, investigation has taken place. Maybe that they have said there is no case against you. The decision has to be taken
by the court concerned.
After hearing the complainant or first informed, in the light of that Rupen Devol Bajaj versus KPSK, 1995 Supreme Court.
The citation.
Based on that, then you have to take the decision. At this stage, the petition is, I do not entertain this petition.
That's what
the best what I can do is, we'll dispose of this petition, is 1990s AR 1996 SC 309. What I suggest is, I will close the proceedings with liberty to seek its revival depending upon the outcome of criminal case pending against you, so that no prejudice will be caused to anybody. If you are agreeable to it.
That's what I'll seek your lordship's kind indulgence. Your lordship will grant me time till next Monday.
What for?
Plus, I'll just...
no, this is the law.
Well, I completely bowed on that.
I have cited the decisions to you.
It's only till next Monday in the sense that I'll just run this through the petitioner once, because I just wanted to...
Yeah, you want to put it to your question.
Yes.
Call this matter in the 18th?
How about nice months?
49.
We lawyers should read all branches of law. They can't say, we only constitution. What's that? Constitution is an adjective. After all, you draw a lot of milk, lot of water from other branches of law. Yeah.
May I please, my lord, I pray your lordship may kindly grant me 3 weeks time.
3 weeks time?
My lord, so that I can file certain documents which I got in between the pendency of...
2 weeks will give you. That's the request now. Next.
49.
Yes. Make sound. Nancy. Yeah.
Madam, in this case, my lord, I am challenging the order under Annex 9, wherein the Director Higher Education has rejected my claim, my appeal, my lord.
What was your appeal before?
I filed an appeal before the Director Higher Education, challenging my order of challenging the action of the opposite party, the governing body, in preventing me to discharge my duties, which I am not
dismissal.
Madam.
No order was passed, but you are kept out of the employment.
No, order was passed. I am
also was passed.
Yes, madam. I am challenging that. Under Annex 9, dated 28/7/2023.
What it says?
It says, my lord, I'm placing some facts. Obviously,
You only
the director has rejected my claim.
of
My lord,
claim for
my claim was before the director was I was illegally prevented by the governing body to discharge my duties, which amounts to termination. Accordingly, I filed an appeal before the director. And the director, in the first instance, my lord, by the order dated 19/7/2018, let me kindly mark this date, 19/7/2018, under Annex 3, allowed my case.
Allowed means?
Directed the governing body to reinstate me in my service, my lord.
Okay.
You will find it at page 25.
I believe you.
My lord.
Reinstatement was ordered.
My lord. Annex 3, page 24-25.
What happened to this order?
The director directed the sub-collector that directed me to file a joining report before the sub-collector, and accordingly I filed it, but it was not accepted. And on the other hand, my lord, the opposite present OP number 5, who claims herself to be appointed in my termination vacancy, she filed a petition before this honorable court.
What happened to that?
That was disposed of with an observation, and the order of the director under Annex 3 was quashed, and the matter was remitted back to the director for fresh hearing.
That was WPC?
The WPC number 16089 of 2018.
Decided on
19/7/2018.
How can that be? 19/7/2018, you said reinstatement order.
Miller?
You said reinstatement order, 19/7/2018. Annex A3, page 24-25, you said.
My reinstatement order, Miller,
There must be some wrong date.
Sorry, sir. Disposed of. Yes, ma'am. Sorry, madam. That was
the date of disposal of WP.
22/7/2022.
22/7/22.
Ma'am.
So it set aside director's order and remitted the matter for
to the director for fresh hearing.
After hearing a lady who had occupied his vacancy.
But my case is, my lord.
Yeah.
The OP number 5 was never appointed in my termination vacancy.
No, we do not know. Court said that way.
No.
Court squashed
Yes, ma'am. But I have to substantiate my case as because, my lord.
One second.
One second.
Now, you were prevented from discharging your duties, correct? So you went in appeal before the director. Appeal was filed under which section of which law?
Appeal was filed in view of the government letter dated 27/3/1983.
27/3/1983. It provides for appeal to the
director. In case of college, it is before the director, and in case of the school, it is before the district education officer. In the education, sorry, direct secondary education now. What's here? So, you will find it at page 1088 of the education manual.
Okay.
That notification.
Anyway, it provides for appeal. Mr. Monti, do you dispute that legal position? That appeal lies to the director?
Legal position I am not disputing, but disputing is there is no such appeal.
There was no such appeal?
No. By virtue of the court's order, subsequently they have filed the representation, and after much late. And so far this vacancy is concerned because of this unauthorized absence for a quite long period.
During what period he remained absent?
Well, remained absent since October 2002. Joined as a lecturer in 98, 15/4/1998.
15/4 appointment.
An absence from the month of October 2002.
Absent. When he went before the director, you say that he did not go to director at all. That's your case. But did you take that stand before the learned single judge?
Yes, ma'am.
But still, the learned single judge said,
No stand is there. Page 6 of my writ petition. Page 6 of my writ petition.
6.
My lord, I filed an appeal before the director in the year 2004, my lord. That is on 16/3/2004. It was not attended to. I approached this honorable court. You will also kindly see page 6.
Directed to consider.
Yes, my lord. The wording you will also kindly see. He is now disputing that it was not there.
There is an order to consider.
Yes, my lord. My representation. And accordingly, it was considered. And you will also kindly see what director hold in the previous order for a moment. Annex 3. Only
previous order.
Yes, ma'am.
2018.
Yes, ma'am. For a moment, I am reading one paragraph here. Page 25. The dispute arises when the principal of the said college did not permit her to discharge her duties and did not permit to take classes and now allow her to put signature.
I'm not.
Sir, not allow her to put signature in the attendance register with effect from 16/3/2004. The present principal submitted that it reveals from the records that the appellant and was continuing as a lecturer in Bakaran in her joining dated 15/4/1998. She further submitted that the principal did not provide her any document, public papers in the matter except to Xerox copy dated 2010-2002 and 29/6/2003, where it is stated that the appellant has been terminated by then management with effect from 26/6/2003. Further, the present principal has submitted that no other documents, papers relating to the appeal are available. But the appellant submitted that she was prevented from.
So he directed that issue should be permitted to resume the duties.
As because principle of natural justice was not followed, my lord.
And nobody was appointed to your.
Yes, my lord. And when the opposite party number 5 filed a petition before this honorable court, he took a stand. She took advantage of this line, my lord. When the director hold that no other persons are there, he took the advantage of that, and basing upon that, this honorable court remitted the matter and said that since an person is there, the director is directed to give opportunity of hearing to her. So, my lord,
so this is a fighting between two women.
Yes, my lord. So, my lord,
represented by two men.
So,
I am appearing for the opposite pattern of 5.
You are also there.
So, let me complete. Similar, my case is the OP number 5 filed her case before the director, styling herself to be appointed in my termination vacancy, which is not at all a fact, my lord. Because, my lord, my case is I was prevented to discharge my duties from 16/3/2004.
16/3/2004.
4, my lord.
No, October 2002.
No. Sir. Now they are saying that I was terminated from that post, from that date. But that is not the fact. I am showing the RTI report, Miller.
1 second. Your date of appointment is?
15/4/1998. 98. Again, the post of lecturer, Sanskrit background.
Background?
Sanskrit background.
Was she student of Panini?
Yeah.
Panini is the great author.
Panini is Ashtadhyayi in grammar. Pattern. And
I joined the post on 15 on the same day. I joined Miller.
Same day.
On the same day I joined the post.
Reported for duty.
Miller?
You reported for duty.
Miller.
Okay. And you worked without any disturbance how long?
Up to 16/3/2004.
Up to means up to 15/3. 16/3 you were sent out.
Miller,
not permitted.
Yes, ma'am.
Then you will file the appeal to the director.
Director on 23/2004. 20th March 2004.
The director made the order on 19/7/2018.
My lord. Allowing my appeal.
Directing that you should be permitted to work.
Please, ma'am.
That was challenged by the lady.
OP number 5.
OP number 5. In that WP.
WPC number 16089 of 2018. WPC number 16089 of 2018.
Remained.
It was disposed of on 22nd July 2022.
Saying she should also be heard, then you should make the order.
Lord.
Correct.
This Honorable Court directed that she should be heard.
Correct.
But this Honorable Court did not say that she is a necessary party to my proceeding. No, this Honorable Court hold, since she is continuing there, she should be heard. My lord. So, my lord, then my lord,
she was heard, order was made.
Made, my lord.
When?
28/7/2023. That is under challenge.
The director held in favor of the lady.
The director has gone a step ahead, my lord. In my appeal, whether it was to be allowed or dismissed, but in my appeal, the director had directed that you approve the service of OP number 5. Though she is not in
the order is dated.
Dated, my lord, 28/7/2023. At Annexure 9.
23. He directed that that lady should be permitted to continue.
The director hold that in my termination vacancy, the OP number 5
appointed.
But I am clarifying the position for a moment, my lord.
In cases she was not appointed to your vacancy at all.
She was appointed much before my date of prevention, even if before the date of termination, my lord. I am showing her date of appointment.
So you mean to say she was appointed much before you were appointed?
No, I was terminated.
But
I was appointed.
So that, okay, there was no vacancy available to her for being appointed so far as you are concerned.
My lord, that is my
holding the post.
Yes, my lord. For a moment, page 27. Page 27.
What is that?
That is the appointment order of the OP number 5, my lord.
You are appointed lecturer in Sanskrit grammar.
On 23. On 23/3/2023, Miller. Kindly mark this dates, Miller. It's very important. It's 27.
This is Annexure?
Annexure 4.
OP5 was appointed.
OP5 was appointed.
Where was which post she was appointed? Grammar only.
In the second post of Sanskrit grammar.
There is a second post also.
No, Miller. It is her own admission that she was appointed as against a non-existent post, Miller. I am showing her counter.
She was engaged. Her services were engaged. It was not a case of appointment.
Engaged as against a non-existent post. It is her submission. I will come to that point, Miller. So, she claims that she was appointed on 23/2003.
At that time, you were not yet removed at all.
No, Will.
You were removed in 2022.
No, Miller.
He said October 2002.
No, Miller. I was, according to them, though I am disputing the termination order, I was, disengaged from 25/6/2003. Roshan, kindly mark the date.
That is 3 months after she was appointed.
Yes, before. When I was terminated, just before 3 months she was appointed.
That's what.
Mark.
You were terminated on 25/3?
25/6/2003.
So your case is she is not appointed to your consider.
My case is, Miller, I was never terminated. Rather, I was prevented to discharge my duties from 2004. Accordingly, I filed the appeal and it was heard. But before the director, what the governing body produced before the director, 2 Xerox copies of 2 documents, Miller. No original, nothing, which was disputed by the director. And accordingly, director came to a conclusion that this is not the sufficient document that you can prove that I was terminated. So the director directed the sub-collector to reinstate me. So, but now the opinion number 5, what she's doing, she's claiming as if she was appointed in my termination vacancy. So that the director came to a conclusion that since she was appointed in my termination vacancy and my termination is justified, let her be approved. This is the case of the director. You also may kindly see the order of the director for a moment.
So question is 2-3 questions will arise. Related question. Whether you were terminated or not. First question. If terminated, whether to that eventual vacancy, OP5 was appointed or not. These 2 essential questions. 3, whether your termination is justified. If 3 is answered in your favor, whether she is independently appointed to your post or to a post other than your post, very insignificant. He has to yield.
That is my case, no. And the governing body
who appears for that. Do you dispute your appointment letter dated 20 March 2023?
No, that is my appointment. That is my appointment.
Your appointment. Then you were appointed much before you were removed. Sure.
Yes, I am satisfied, Lordship.
No, I am asking you just to know.
Your Lordship. I am
he is saying, I was removed on 25/6/2003.
He is not saying so. He is saying I was prohibited in the year 2004.
But the English words, because preventing an employee from working amounts to removal. There is such a judgment.
Yes. Hon'Ble versus State Board.
In that context, I say.
Yes. That is nice. He is saying, Miller, I am pardon Miller. He is saying that in 2004 I was prohibited, but the governing body is saying that in 2003 he was terminated.
2003 on 25/6/2000.
Yes.
But you were appointed.
I am appointed on
20 March
2003. Yes.
Then where is the question of you occupying that vacancy?
Yeah, I will satisfy on that. I will satisfy on that reason. The petition was appointed in the year 1998.
Correct.
She was continuing there since 2002. Then she remained unauthorized absent in the college.
From which year?
From October 2002, she remained unauthorized absent in.
Any notice was issued to her?
Yes.
That is the fact.
Oh, yes. I will satisfy your lordship. Your lordship may see my counter filed by the opposite party number 5. Counter, lordship.
No, I have one question, just clarification.
Yes, ma'am.
Anyway, you were appointed on March 2020, in March
2003, Miller.
2003.
Yes, ma'am.
Correct.
Yes, ma'am.
So at that time she was working.
No, she was unauthorized absent.
In March 2003?
Yes, ma'am. From October 2002, she was unauthorized absent. When the study of students were hampered, the governing body of the college served notice her. Please join in the college. The students of the study of the students are hampering.
Where is that the notice?
Yes, your lordship. But kindly come to my counter. Filed by opposite party number 5.
OP3 counter. OP5.
Yes, ma'am. Counter filed by the OP number 5. Got it, Miller?
Yeah.
Your lordship may come to the page 15 of my counter.
115.
15. Annexer C by 515.
What it says?
Your lordship.
College?
Yeah, that is in the heading. Got it, your lordship?
Yes. College, you come to the
I am submitting
within 1 month.
I am.
I have read it now. That was sufficient.
Your lordship, kindly take just 1 minute.
This is dated what?
This is dated 20th October 2002, Miller. 20th October 2002. 20th October 2002. Your lordship, I may permitted of the paragraph 1 minute to take hardly 1 minute. Your lordship, I am to Miss Tapaswini Patnaik, lecturer in Bakarana at Madam. It is observed that you are not coming to the college. As a result, which the teaching of the college is badly affected. I personally went to your house, and met your father. He told me that she is not interested to remain in your college, as your college is an unpermitted and unrecorded college. I intimate you that if you are intended to remain this college, you come to join within 1 month. Otherwise, it will be stated that you have no more interest to remain in the college.
Was it served on you?
No, ma'am. Yes, that is served on her.
No, see, in that case, in that letter, you lordship may kindly see one discrepancy I am showing. You lordship may kindly see from the bottom. It has been issued by the principal cum secretary in the year 2002, Miller. At that point of time, in the year 2002, the institution was a purely unaided institution, Miller. So the institution was came to the granting fold in the year 2015. Once the institution becomes aided, Miller, thereafter the principal can be the secretary of the ex officio secretary of the institution. But you will also kindly see when the institution was unaided one, how could the principal serve the notice as principal cum secretary of the institution?
No, I want to know. Even in an unaided institute,
yes,
there can be a secretary.
Yes, Miller.
There can be a secretary, but the principal cannot be the secretary.
The prohibition for principal being the secretary.
Yes, I am showing.
I am satisfied also. Before going to the here the signature.
No, I am getting satisfaction, but all are getting dissatisfied.
Yes. Rule 25 of the management rule, Miller. I am reading. Page is 671 of the education manual. Governing body of aided higher secondary school or junior colleges, notwithstanding anything contained in these rules, as soon as a junior college or a private higher secondary school becomes an added one, the
principal becomes the
ex officio secretary of the institution.
That's all.
So,
I satisfy in this regard.
I want to know how this letter was served on.
Yes.
How this
let him show.
That was served on, Miller. That was served by the post.
By post.
Yes.
Very.
That was, I have not annexed the same.
Where have you stated that? It is served by post. How you will come to know? You are OP5.
Yes, Miller.
But
Yes.
the management will know.
I will satisfy you.
Unless you are handing glow with the management itself.
Yes. I will satisfy you, Lordship.
No, I want to know. That's all. I am not asking for money order. I am asking which postman carried this letter to her.
This letter, the management filed this as a letter before the director.
Who appears for the management here?
Management, no one is appearing for the management. It was filed in the counter reply before the director. The governing board has filed such letter.
Whether this letter was disputed before the director?
Yes. It was disputed. That's why the director in the earlier occasion came to a conclusion that those two letters are not acceptable and the principle of natural justice has not been followed. That's why director didn't set my service below. Only two documents. These two, there is
one submission, Miller. One submission.
Let him submit one document that, let him submit one document that she was ever appointed in my donation vacancy. That's all, Miller.
One submission, Miller. Here, Miller, she is alleging that she has been prohibited in the year 2002, 2004. And accordingly, at Annexer, Miller, at Annexer 3, Miller, kindly have a glance.
No, I want to know how this letter was served on that.
Only I got that letter.
How you get that letter?
It is in the counter filed by the governing body for the director. I got that counter. I have annexed.
Counter you have annexed, all right. But she said, I never it was served on me. And that the director found the letter to be only Xerox copies.
That has been filed by the governing body for the director.
That he did not agree.
No. She agreed. In the final order, director agreed with that. In the final order, what director has passed, he agreed with that letter. Director.
In 2000.
Yes, Miller. The final, your lordship may come to the final order passed by the director.
That
at Annexer
2018 order.
No. Final.
This order I am speaking.
Oh, 18 order. Your lordship may come to the 18 order. 18 order at Annexer, Miller. At Annexer, your lordship may come to the page 25. 25 of the writ petition.
Yes, it goes against you.
I am reading that order. Operative question. In such view, I am the opinion. The dispute arises when the principal of the said college did not permit her to discharge her duties and did not permit to take classes and not allow her to put signature in the attendance register with effect from 16th March 2004. The present principal submitted that it reveals from the records.
Okay, again. All right. There should be some tamasha in the court also. You continue.
The present principal.
You do one thing. Who does tamasha now? When he argues, you do it same when you are sitting behind. Because I cannot say more to all learned members. Yes.
The present principal submitted that it reveals from the records that the appellant and was continuing as lecturer in Bhakaran while his joining dated 15/4/1980. She further submitted that ex-principal did not provide her any documents, papers in the matter except 2 numbers of Xerox copy of the letters dated 20th/10/2002 and 29/6/2003, where it was stated that the appellant have been terminated by the management with effect from 28/6/2003. Further, the present principal has submitted that no other document paper relating to the appeal are available. But the appellant submitted that she was prevented from discharging her duties, and before prevention, no opportunity was given to her, nor any so-called notice terminated her as a issuer. It was not submission, then order of the director. In such view, I am the opinion that there is no dispute that the appellant was appointed in the college as lecturer in Sanskrit Bhakaran, and till date, no other person has been appointed in her place as revealed from the written note of principal concerned. In such a view of the matter, the sub-collector Jagatsinghpur, who is the president of GIPG, hereby directed to allow her resume her duty with the immediate effect. Here, Miller, in this case, the principal has filed the written note. The written note is very much available in my counter. Here, the principal category stated that one person, namely the opposite five, has already appointed, but omitting the same, the director wrote written here that no one is appointed as principal as stated. But here I have in my counter reply, I annexed the written note of submission submitted by the principal.
No, you were appointed on 20 March 2003.
Yes, yes.
Removed. This removal is from 25/6/2003.
There, Miller.
So you are not appointed to that vacancy at all.
Yeah, I am not appointed that vacancy. When she remained absent from 2002 unauthorized.
When the remain unauthorized.
Yes.
Where is your case that you are appointed to the eventual vacancy?
I was appointed on stick for that year admitted, Miller. When she remained unauthorized absent,
we will come to that authorized absent or not. Whether absent is unauthorized or not, I will come to that one.
Yes, Miller.
The fact remains, as he rightly said, you are not occupying her vacancy at all.
That is admitted, Miller.
If you admit that, then what is your voice here?
Why? I am submitting, Miller. When she was absent in the college for exigence of students, I was appointed. And yes, Miller.
Where is that appointment?
My appointment was at Annexer, Miller, at Annexer, a read petition, Annexer 4, page 27.
That is 20 March.
20th March.
20th March, she was very much there.
No, Mira. From 20th March 2003, she was remained absent with effect from October 2002, Miller.
He's saying.
Management is saying that she was absent, the letter said she was remained absent unauthorized with effect from October 2002. When there is exigency for the students, I was given appointment, Miller, and I was taken class. After her termination, I was adjusted against second post. Till that I am continuing. Apart from that, one submission, Miller. She was prohibited. She filed a appeal, Miller, at Annexer 3, page 22. 22, Miller. That is on. I was prohibited in the 2023. Accordingly, I filed appeal on 20th March 2004. She filed appeal on 20th March 2004, Miller. 20th March 2004. But she has not filed any acknowledgement letter regarding her filing of appeal. Miller, government in his counter categorically stated that he has not filed any appeal on this date.
But then, learned single judge remission.
This is the question. You will see me come to the by the Lawrence at page 6 of the writ petition. Page 6 of the writ petition. That is the point. That is the point. Just a minute. Please, your lordship may come to the para 6, page 6.
That is respectfully submit this.
Page 6, your lordship got it? It is an order of 2000. He filed an appeal in the year 2004, Miller. But he filed a writ petition before this Honorable Court in 2010 when the appeal was not disposed. What happened here, Miller? In 2009, the granting order 2000 came to the picture. The petitioner was removed. When the granting to the picture, he immediately come to this Honorable in 2010. 2010, Miller.
When granting aid was?
2009, Miller.
The notification came into force in the year 2015 with effect from 2009. But the notification
as of that date, it was not there at all.
No,
retrospective effect.
Yes.
2010, after 6 years, then the order of the Honorable Court, Miller.
No, what you say, there is one famous statement. Those who lie on the verge of the truth are most dangerous. You are telling the granting aid the institution got with effect from 2009.
Yes, sir.
That is with retrospective effect after the order was made in 2015.
Page 29. Page 29, Lordship, kindly see. Page 29. Annex 6.
Mollified way that because the institution is admitted to the grant, she all of a sudden woke up and came. That story is difficult to believe.
I am submitting. You kindly base the order passed by this Honorable Court. Had the Lawrence counsel for petitioner, the grievance of the petitioner in the writ pit application that she has filed a representation dated 20th 3/2004, Annex 3, before the opposite party number 3, Director Higher Education Orissa, Bhubaneswar, highlighting her grievance, but same is still pending. In view of such submission, we dispose of the writ petition, directly the opposite party number 2, Director Higher Education Orissa, to take a decision on the representation of the petitioner by 15th September 2020 if she is still pending. The petitioner is directed to produce certified copy of the order along with the copy of the representation dated 20th March 2004 before the Director Higher Education on the 9th August 2010. On this appearance, the Director shall fix a date hearing and conclude the same within the stipulated time, giving opportunity of hearing to the petitioner as well as any of the parties if he consider necessary for proper adjudication of the case. As per the direction of this Honorable Court, the petitioner
was on 22/7/22.
10.
22/7/10. 2010.
Yes, Miller. As per the direction of this Honorable Court,
26/7/2010.
26/7. Direction of this Honorable Court, the petitioner produced the representation dated 20th March 2004 before the Director, and accordingly Director had the petitioner. My submission before this Honorable Court is that your Lordship may kindly come to the circular dated 27/3/83. Kindly have a glance to the circular.
Which provided for appeal.
Yes. Which appeal provision? That is, what
does it say? Even if you read, I can remember.
Yes,
within 30 days. What do you mean to say?
Why I love it? This is
for what point you want to read this?
Only the period of appeal. Previous 30 days. Yes, 30 days. That is 30 days. My respect to submit before this Honorable Court is that on 23rd 2004, no appeal was filed before the Director. That is categorically the Director in his counter. Your Lordship have a glance to the counter filed by the government.
Said that. But why, despite that, court said that.
Court said that you produced the representation dated 20th March 2004 and the order dated 26/7/2010, as per direction of this honorable court, the director had this appeal. But actual no appeal was filed. Can you have a glance to the counter filed by the government?
You have open your case.
Government.
Don't have open
Government counter. Can you have a glance?
To satisfy that you are ever appointed in my case. Plus.
See, the counter filed the government, para 7.
Para 7. There they have second, he has not filed appeal.
Yes, sir. It is the government.
Wait, I agree with you if you say.
Yes, I am just reading.
Read.
I am reading.
Read.
That in paragraph 12 of the writ petition, the applicant submits that she was hindered from discharging her duties in terms of taking class in the college and putting her signature from 16/3/2004 by the college authority. Therefore, she filed an appeal dated 20th March 2004 before the Director Higher Education Odisha. In this connection, it is to submit that as per the report of the principal IC of the college dated 16/9/2023, Srimati Patnaik has been absent in the college since October 2002. Moreover, as per the RT application dated 1st August 2022 of Mrs. Nanda, who has been arrayed as opposite partner to this RT application, the matter was inquired by this office and it confirmed that no such application of Srimati Patnaik dated.
How you filed that appeal?
Yes.
Myself, Lord.
Where is the seal on the?
Well, at that point of time, in myself also, the particular appeal, I myself had filed before that, because at that point of time I was in the profession, my lord. You also may kindly see, at that point of time, all my learned seniors and friends knows that at that point of time, if we file an appeal before the director, they generally they do not give the seal and signatures. But my
whole diary number. Every diary number.
Please
every application of the state post mail. You are submitted misleading the honorable court. Every application has to be submitted by.
Please sit down. So honestly, see, he's saying that I am misleading. I am submitting my case before my lord.
You should not say.
Yes, sorry.
You should not say sigma. That is my problem.
He's using the word that I am misleading. This is not fair. And my case is, my lord. Once I was prevented to discharge my duties,
You said that during those days.
But this
I'm telling what you are saying. Even that you object.
My lord,
I want to say what you say. That you will object.
No.
You should be kind. You should be kind to the judge. Is it not? You should be kind to the judge also. The judge should be kind to the members of the bar. Members of the bar should be kind to the judge. Then we can decide the things. It's not after I'm hearing you at length is another thing. Because you should not go from my court with the feeling we have not been properly heard in the matter. That impression I don't want to. I have understood the case now. Okay, lots of jugglery I did when you were fighting with each other in a way. Now you said during those days, no acknowledgement was given. There no entry was at least there was a register. I'm telling
my reply to your lordship's query is, if there is no appeal before the director, Miller, in the first instance, what was heard by the director? The director heard my petition. Before the director, in the first instance, when the order was passed in the 2018, nobody disputes it. Even the director, Miller, he did not say that your appeal is not there. He heard it. Accordingly, passed the order. Even in the present order, your lordship will find it Annexure 9. There is no such whisper. And the director has never said that your appeal is not there. Rather, he has heard it. If my appeal is not there, then it is the authority, it is the director, it is the appellate authority who can dispute it, that your appeal is not there. Not a single word has been whispered by the director
when the first order was made.
Yes. Annexure 3.
First order was made on 1917-18. At that time, he did not.
No, not a single word. If you lordship allow me, I will read.
It's a very short order.
A short order. Even in the present order,
he would have said, Where is your appeal?
Yes, that is my case, ma'am. And in the present rejection order,
Director of this honorable court direct had this appeal, not the appeal is there. As per the order of this honorable court, and the petition was filed before the director. As per the order of this honorable court.
Yes, let me complete.
This honorable court categorically directed you filed the appeal before the director and the order before the director. That's not the matter.
So, Lord, in the present order, which I am excelling now, order Annex 9, you Lordship may kindly see for a moment. There is no whisper that my appeal was allowed there. Then who is he who has no locus standi to challenge my authority or my appellate position or my termination position? Now she is coming forward and saying that I have not filed an appeal, but the director has heard it. If the director would have said that there is bill, then Milord, it's all right. It would have been disputed. Director in 2 occasions heard my case, no whisper with regard to my appeal, and rather he has accepted. And what my learned senior friend is referring the counter, my entire allegation against the director is the director is hand in gloves with the present present open number 5. Is why I am saying so, Milord. You will also may kindly see. I am relying upon his counter. Page 57, running page 57.
One second. I may clarify my doubt, which is in your favor. Brother, she was appointed on 15/4/1998.
Yes, Lord.
Which person will quit the job and go that way? Having served, even according to you, October 2002, she abandoned the job.
Yes.
Why she will do that?
As because at that time, as speaking, Milord, she was a sound person. At that time,
Bro, this story. You have made lot of sound. We fully agree. Not only her advocates are also.
She ordered, particularly the letter, the principal of the college went to her house and requested her father to join her. But her
father said she not. Letter itself is this.
Unaided and unpermitted college, therefore she did not join.
Mr. Mohanty,
my lord,
how the letter was sent to her, asking her, see, if you say, come and join, there must be some letter which postman carried it.
I have to reply.
This is given by the secretary of that management governing body, Milord.
No, secretary is principal cum secretary.
Principal cum secretary.
He is making allegation against the principal cum secretary.
Whether in an
in the ending role with the
that person has given appointment to his client also. That particular Hare Krishna Swami may be an appointment to me, appointment to she signed the
secretary, not as
letter. Whose signature he is disputing. His appointment was signed by that person, particular that Hare Krishna Swami.
As the principal.
Yes, you are principal.
The secretary.
And secretary. You were not principal at.
Yes, your advocate was working as principal and secretary both of the college.
How it could be? How it can be?
Perhaps some senior advocate has to sit in between these two persons. I am afraid they will not go home so easily.
And so far as your lordship queries with regard to service of notice, I have obtained the documents under Act, page 136. Your lordship may kindly see. It will clarify the position. 136, the running page.
136.
Well, 136. This is the RTA application. Lordship got it?
Yeah. As per your application dated.
Yes, ma'am. You lordship may kindly see clause number 4, Roman 4. The attested copy of proof of service
is not available.
Is not available. So now the college is saying that it is available, and more so, everything will be clarified from a counter filed by the governing body in the previous case. For a moment, your lordship may kindly
say.
Yes, ma'am. I am reading that. Page 35.
Page 35 of my brief, drawing page. Paragraph 7. 2 to 3 paragraphs I am reading, my lord.
How can you read? We need one more day for you.
Sorry, paragraph 8. Lordship got it. They are the averments made in paragraph 6 of the writ application. It is not correct. It is stated here that before the termination of service of the OP number 6, in that case I was OP number 6, my lord. Before the termination of service of opposite party number 6, dated 29/6/2003, the recruitment process of the petitioner, the present OP number 5, my lord. The petitioner was completed. The advertisement for recruitment, please wait. The advertisement for recruitment of the petitioner has no connection to the post held by the OP number 6. That is myself, my lord, which is clear from Annexure 3 to the writ petition.
Who has said this? Government has said.
No, the college has said it. The principal has said it. Lord, may kindly see. Page 34. On affidavit, the principal has filed it. And the principal has said that the principal has admitted that she was appointed. What she was appointed most before me, and she has no linkage with my termination vacancy.
I am admitting the same. I am admitting the same. Only my point is that he has not filed any appeal for the director. My submission as per the counter filed the government as per the provision contained in 27 March 1983.
All right. Judgment tomorrow.
Okay. 71, that matter, transfer matter.
G was saying they are to file objections in that.
Yeah, objection, but what happened, my lord, my client particularly, there is no interim order in my favor. I am challenging that notification itself. So last time also my learned has taken time only to file counter.
It will be short time. Short time. You and you hear all those matters.
Yes,
series of matters are there. That point of
I will post them, all these matters I will post.
17, my lord.
17.
Other matters are coming.
Item 71.
Item 74. Item 74.
71, wherever interim order is there to continue.
Item 74. Let it come tomorrow, my lord. Because they are not released from the suspension allowance from 2021, my lord. They are releasing also 2 times.
Day after week. Yeah.
Item 67 matters.
Yes.
Exactly same case which was being
argued now.
Let it come, but they have not given a counter.
We'll do it. We'll have it next week in the middle because tomorrow I may pronounce this judgment.
Item 61, item 52, my lord.
Next week. When? What's the urgency, brother? Promotion is never treated as a
Item number 61, my lord. Pension matter, my lord.
Pension
matter, my lord. 61. 2014, my lord.
See the dates.
Which your lordship could not. This is a matter where on the last occasion, when hearing had just commenced, the central government wanted time, and I had requested, when the matter was posted to today, I had requested it to be fixed at 2 p.m. Your lordship had said that yes, it will be taken up on that day. And somehow, because of other matters, it could not be taken up. It's an important and urgent matter in the sense that it concerns a child care institution where the institution is going since 2018. And they are living by money in the market.
Mr. Mukherjee, choose a date.
Tomorrow.
My lord, item 52.
You are an erudite lawyer. I am not erudite judge. What you have to keep in your mind?
Your lordship, whatever date is convenient, your lordship, kindly fix it at 2 p.m. on any day convenient to your lordship.
On the 19th, we can.
19th.
How many matters, brother?
There are 10 matters.
Yes, 19th to 14th.
Your lordship, fix it at 2 p.m.
Very difficult because there is some objection from the bar members. They came to the member and said, sir, you are putting it at 2. All the senior other matters will not only 2, only first matter it will be, you will take up that matter. They said there is sense of
that sense of dissatisfaction would be there across the board because because of exigencies of certain matters having to take precedence over the other, your lordships are doing it. The other courts are doing it. Matters which cannot brook any delay, which are now being taken up, are being fixed at 2 p.m. I leave it to your lordship. Whatever.
On 20th, you just mentioned at 2 p.m. So it was there.
It will be listed, you have shifted 19, the 20th.
19.
Item 58, Millard, item not 58. Let me on come 70. What is that? 58.
It should come separately.
Item 58. So 58, that is, my post has been approved. But due to an interim, I am not getting my salary.
58. When do you want?
17.
58 is just now
How many
counted.
meters are pushed?
17, 13 meters, sir.
17, 30.
Okay, next is the 20th, sir.
When it is posted,
Item 52, my lord. Item 52.
that day. 24, sir, right? 24. Oh, 24.
Item 55. Item 52, my lord. Item 52.
This is the promotion ban.
Promotion men are not getting lesser scale of scale of payment. Item 55. Item 55. Item 52, my lord. Item 55, my lord.
What's the urgency?
Urgency is my lord.
We'll see that then.
Item 55, my lord.